6.
7 withdraw.
Your Lordships, item 5, Your Lordships.
Yes,
I pray for next week, Your Lordships.
it will go to March.
I,
Yes.
Item 6, Your Lordship, may be
Yes.
adjourned. Item 6 may be adjourned.
March, April. Okay, all these matters are unnecessary pending. These people are asking. Time means there is nothing. Yes.
Item 14 to 27. Item 20 to 34. Item 35 to 43. Item 44 to 50. Item 51 to 58. Item 59 and 60.
My lords, item 59.
Yes.
It's an appeal against conviction. I'm praying just not today, my lords. I have some personal difficulty. It may be tagged in the weekly list and it can be taken up there.
2012 matter
Yes.
for a final hearing.
Yes.
So why it is listed here? It can go to
Yes, my weekly list it can be
weekly
tagged.
list.
Yes. Yes.
Weekly.
Yes. So grateful, my lords.
Monday weekly.
Item 2.
Item 2, I may be permitted, my lords. My lords, petitioner is the complainant in the court below who filed a 138 enact proceeding against the present OP,
Yes.
my lords. And the learned STGM Barampur, by the order dated 26/10/2022 at page 18, my lords, was pleased to dismiss the same due to non-prosecution, my lords.
Non-prosecution.
Non-prosecution. And by the annexure to page 19, Millers, petitioner filed a CRP before the learned session judge to set aside the dismissal order, Millers. And by the order dated 26/6/2024, annexure 3, page 25 onwards, the learned session judge dismissed the CRP on the ground that there is a delay of 482 days in preparing the criminal.
Are you really serious in this matter?
Millers, we are
This matter
serious.
is pending since 2013.
Millers.
You have not taken any step.
Lord, so that is there due to some illness and other difficulties. It has not been. So one opportunity, if it is maybe possible, Millers. My statutory right me being frustrated, Millers.
That's right, but these are
Yes.
this is 138 matter.
Yes,
2013 it is pending. Just see the proceeding. Page 12. Come to page 12.
that is true, Millers. I don't dispute that is there. As per records, Millers, there is.
What is the check amount?
My lords?
What is the check amount? What is the check amount?
I am submitting, my lords.
99,000.
Hmm?
200. The page 11 also.
99, my lords.
99,286.
My lords, 99,286.
I don't think it is.
My lords, one
2013.
opportunity. One single opportunity may be given, my lords.
No, that's right, but it is the burden on the court because see your conduct. Your conduct is very. It is not even a 1 lakh rupees. For 1 lakh rupees, why unnecessary? But
Lords,
I don't think it's, had it been a good amount, I could have interfered.
Lords,
But this is only 99,000 rupees. 2013 you have been doing it. Dismiss, delay of use days.
my lords, that quantity, my lord, differs from person to person. 99,000 is a.
That's
big
right. He
amount for
will.
this
I'll tell
person.
you. He will waste more money in prosecuting the case rather than getting it.
My lords,
This
one
is the end of the day. I don't think. Put
one
an end to it.
One
Put an end to it. Unnecessary. Why?
one opportunity and my lords, one opportunity I will not.
Then I'll just see issue notice. If he comes, he pays some.
Yes.
I'll just issue notice. He may come and pay something.
Notice may be issued.
I'll just issue notice. Let us see.
Yes, lords.
I'll persuade him to pay you something.
Yes.
If not, check amount something.
Yes.
Okay.
Yes.
Simply issue notice. Yes.
Item 3.
May I plead, Your Lords?
Yes.
Item 3, my lord, I am the accused in the court below I have filed a petition under section 311 of CRPC by annexure to page number 12, my lord. Some questions have not been asked as regards to exhibit 7 and as regards to income tax of the complainant. But that petition has been rejected by the learning court below. By annexure 4, my lord, by the order dated 10/7/2024. On the ground that the questionnaire form has not been given.
Now, why you have not put the question that you have not explained?
My lord, I have in page number 12 by the petition, in paragraph number 4, my lord, I have specifically mentioned that I want to ask some questions regarding exhibit 7, that is the bank transaction, my lord.
Now, what, this is a case, complaint case,
My lord,
138.
my lord. In the meantime, I have already paid the 10% order has been given, and that I have already paid
Check amount.
5 lakhs, my lord.
See, the objection has, he has filed the objection also.
He has filed the objection, my lord. The only ground that since I have not given any
See,
question.
no, that's right, but see, the witness was examined in December 2022. You have been taking time, and eventually you cross-examine in 28/7/2023. Thereafter also you left one question.
Not
Now you
one
moved an
question.
application. So this is only delay text.
No, my lord. Only one day I'll take
20,000 rupees. Cost.
20,000.
Otherwise, I am dismissing. No negotiation, I am telling you. You are trying to delay the 138 foot. Pay 20,000 rupees and I am allowing one opportunity. I don't-
He's a very
Petitioner-
poor.
or otherwise, no, why have you, we should check what kind of poor
No, my lord.
person you are. You are issuing a check and harassing this man like anything.
That is also disputed.
No further argument. Either you take it or dismiss it.
5,000.
No argument, nothing. This is a 138 case. You must understand that. You have been sufficiently 2019 complaint. December 6th, December 2022, you examined the witness.
My lord, the matter has been.
Then for cross-examination, you took about 1.5 years.
No, my lord.
That's the date.
My lord, the matter.
No argument. These are the basic.
I only pray one line, my lord.
Right on.
The matter has been posted to tomorrow.
Right on, I allow it. I'll allow it pay. Right on. Petition is agreed by the order dated 10/7/2024, passed by the TJM in ICT case number 231 for 2019, whereby the application of the petitioner under section 311 CRPC to recall PW1 of the complaint has been turned up. The complete case is pending since 2019. The complainant was examined as PW1 on 6/12/2022. The petitioner has been seeking adjournment to cross-examine the schedule. Eventually, on 28/7/2023, the witness was cross-examined by the present petitioner and present petitioner. Subsequently, on when we filed this application, 311 application.
My lord, I have filed the application in the on that day.
9/2/2024. The petitioner moved the impugned application under section 311 CRPC. The complainant objected to the same by filing a detailed objection. Taking into consideration the objection and the factual scenario of the present case, the trial court has rejected the application. Then counsel for the petitioner submits that one opportunity would suffice for cross-examining the witness as a vital question is left out to be put to the witness. Taking into consideration the reasons stated in the application and the statements made by the accused bar, I am inclined to allow the petitioner to cross-examine the witness on a particular date to be fixed by the learned court below. It is accordingly the present petition is allowed. The trial court is directed to fix a particular date and afford a competent petitioner to cross-examine PW1 prior to the cross-examination. The petitioner is directed to furnish the questionnaires and it is open for the trial court to examine the relevancy of the questions to be put to the date witness. It is made clear that the singular opportunity to be afforded to the petitioner, petitioner and the complainant as well as the petitioner shall not seek unnecessary. The petition is allowed subject to the petitioner paying a cost of rupees 15,000 to the complainant on the dates of the cross-examination. So we think that the subject petition is disposed. Yes, next.
Madam, may I pray 10,000?
Next. Yes.
Item 8.
Developers.
May behalf of Mr. Naik, I am heard to argue, my lord. What happened in this case, my lord? There are two affairs, my lord. Incident, one incident, my lord. Two affairs, my lord. I am challenging the second affair, my lord. Second affair, my lord, annexer 3, page 52, cognizance taken, my lord, the magistrate, my lord. And this is the second affair, my lord.
What are you asking for? Cognizance order.
Cognizance order, my lord. There are two affairs.
Cognizance order in the second FIR.
Second affair, my lord. What happened, my lord? The truck owners association, the dispute between the management and truck association, lifting up the my lord poles, my lord. And it is alleged on the date of occurrence, some truck association or laborers block the road. In persons that police lodged an information, my lord. Same day. And same day, mining director lodged mining manager lodged another affair. Subsequently, which was
Same incident.
Same incident.
First FIR.
First affair. On page 53.
First FIR.
First page 53.
53.
3.
Okay. Yes.
Former affair 53. Written affair 55.
Yes.
I, Sudarshan Dehuri, such and such, hereby requested to lodge FIR in the effect that to the effect that on dated 6/9/2023 at about 6:30 p.m. I, along with my staff, were on patrolling duty in Borsua and Khondadhara Kurmiti mines area for smooth following up traffic on Minis Road. At about 5:30 p.m., I received information from OMC security that some truck owners and Borsua Trucks Owners Association being instigated by Bajagar Agarwala have blocked the main gate of OMC Khondadhara Kurmita mines and its office and were demanding not to allow 16-wheelers truck for loading inside the mines. After some time, at around 7:30 p.m., laborers of Mrs. Khondadhara Loading Agency, Private Limited.
Second FIR.
Second affair, my lord. This my lord, last part, my lord. The second paragraph is important, my lord. Though myself, along with the local police present there, tried to counsel the unlawful gathering, but they did not pay attention and continued to block the road and mines, hereby totally paralyzing the regular vehicular traffic on the mines road. On
7:30.
And it continues 7:30 p.m.
Yes.
That is important, my lord. First affair, my lord.
It started from 3:30 to 7:30. Yes.
7:30.
Next.
Second affair, my lord, page 13.
1-3.
1-3.
Yes.
Mines corporation work informed that 7/9/2007 next day at about 6:30 a.m. I received information that labor of Mr. Khondadhara Loading same thing. Not the worker blocked the road OMC gate number 1 by halting sales operation of a mine complete, they detain all the vehicles coming from mines towards Borsua. At same time, some truck owners association members of the Borsua Trucks Owners Association blocked the main gate of Permit Mines OMC Limited.
What is page 13?
Page 13, my lord, the second FR, my lord. Written FR. And 51 by the first FR, my lord. And both the cases are submitted, my lord. Instead of, my lord, the second FR, my lord.
My lord, in the past FR, your lordship, there is some, there is a road blockage on 6/9/2023. And you want to kindly see the second FR, page 13. That is on
7/9.
Say continue kala next day.
Next day morning.
6:30 continue করছে next day পর্যন্ত. That is the case. And in fact, my second FR.
I should not just take it up.
Okay, CDS.
CD, call for CD.
Further proceeding, my lord, cognizance taken it. Stay back.
What happened to the first FIR?
First FR का charge sheet cognizance আমি challenge করুন. Same accused persons. We will face that trial in that case, my lord. But
Now you are not challenging. The moment I'll say, then you will say.
no, my lord, I will not challenge. But I have annexed all these things, my lord. This case, my lord, present case. I have annexed the second FIR and cognizance everything, my lord. We have no objection, my lord.
But this is a continuing offense.
Continuing
In
offense.
fact, it started on 6th,
My lord.
continue till 7th.
7:30.
Till 11 o'clock.
Technical election 7:30 जो 7 right क्या करचंदी
They continue. They block the road.
ये petition फाइल कले जो adjournment petition
Adjournment.
start date है ये नहीं
Adjournment. And call for the CD
आगे
and file a consolidated charge sheet.
Interesting, I have filed, they were cited 9 witnesses, my lord. All 6 witnesses, eyewitnesses, those are occurrence, my lord. They have not named any persons, my lord. In the second FIR.
देखिए
No privacy case, my lord.
I think you should file a consolidated charge sheet in one case and
Exactly, my lord. Exactly.
instead of confusing.
filed in both cases मतलब chapter also
And in the both the cases they will be acquitted.
My
If you are
lord.
doing
Exactly,
that.
exactly.
You concentrate in one case, then at least they will be
Ten
convicted.
is there, my lord. I will talk with it.
Okay.
We'll file time, my lord.
Okay.
That will be
10/6, we'll seek for adjournment. Date as per the application moved, simple. Yes.
Item 9.
No, Mr. Jana, I think I should stay.
Stay better. Dita case chalo.
Why I'll tell you. There is a reason of stay. If one stay, then your instruction will work.
My exactly.
Otherwise, this is again the routine way.
Short date है homework खाली आयुष का नहीं दीटा किंतु
You remind me next week. Comment.
next week नहीं
I'll stay.
सप्ताह
Yes.
1 week after
1 week after. Huh? Yes.
Thank you.
May please, your lordship. My lord, the petitioner number 1 is the husband of the opposite party number 2. Petitioner number 2 to 5, in-laws of the opposite party number 2, my lord.
Yes, yes.
The petitioners have filed this application with a prayer to quash the order of a cognizance.
I issue notice. Matrimonial dispute. Matrimonial dispute.
My lord, in the meantime, marriage has already been dissolved on mutual consent by the petitioner number 1 and the opposite.
Okay, in any case, I am issuing notice and staying the proceeding.
My lord.
Issue notice, stay the proceeding. Okay. Yes.
Item 10.
My lord, the petitioner challenged the order under Annexure 4, my lord, regarding framing of charges under section 395, 357 of IPC, my lord.
Annexure 4.
My lord,
page 24
although the charge sheet has been submitted against 2 accused persons. My lord, in 395, 5 numbers of members is required for the constitute the offense, my lord. My lord, in charge sheet, then submitted against 2 accused persons, and FIR was lodged against 4 accused persons under section 457, 380 of IPC, my lord. And thereafter charge sheet is submitted, although there is to my lord, the Annexure 4, my lord.
Where is the High Court order?
My lord, that is Annexure 3, my lord. At the time of cognizance, the petitioner approached, unaware the direction for raise the
The coordinate bench directed that is page 21.
At the framing of a charge.
The raise at the time of framing up for
Charge.
charge, the stage of trial, that is page 21, the page relevant page 22.
My lord, I have filed the petition and the same was rejected.
And, against the discharge, there is the revision lies to this order of impugned order. And another fact is also by in the impugned order, page 25. the
How many accused are there in this?
In fact, two accused are charge sheeted also. And the FIR allegation is more than 6% lawsuit.
More
But
than 4%.
if 6, impugned order 6,
Okay.
27.
390, how will you subtract 390?
95.
95.
That's
How will you do it?
That's right, Your Lordship. But in but impugned order, that's the one of the statement that the 4% the trade with from this part, then I will not to be able to apprehend this end. That is in the one of the statement of the by the government paragraph.
How will you subtract it
That's
395?
right, Your Lordship. 395 is concerned.
I'll issue notice, just check it up.
Yes, Your Lordship.
Issue notice. In the meantime, proceeding state.
Item 11.
My lord, stay away for the question. Stay away.
You don't want. You want or not?
One.
I have done it. If you don't want, I'll take.
Oblige.
Item 11.
Here is the presentation of the husband, 6 per questionment on the entire criminal proceeding. On the ground, the divorce application is pending before the Lion families as Barampur, Your Lordship. Under the Special Marriage Act 27(1) of the D of the Special Marriage Act, Your Lordship. That not been ended in Your Lordship. That was marriage of divorce.
498 and all. I'll issue notice.
Yes, Your Lordship.
Issue notice.
That is not the-
Issue. Yes.
Item 12.
Lordship, may I please? I may be allowed to conduct my case through VC, Lordship.
Yes, yes.
Lordship, in this case, I have challenged the entire proceeding initiated against me by casing a PS case number 192 of 2019. That the FIR was filed because one disciplinary proceeding was initiated against me on 16/7/2013, and accordingly the Tahsildar, Lord Tahsildar Kesinga, was instructed to file this FIR against me. So, Lordship, the FIR was filed on 16/7/2019. Lordship, the entire order sheet, Lordship may kindly peruse. The only one thing is written, that is awaiting effect. That is from 2019 to till date. So, Lordship, I am going to retire in the next year, March 31st. So, Lordship, for that inordinate delay, that I have challenged this FIR.
What is the state now?
Lordship, my Lion seniors prayer is that in the decisional proceeding has been exonerated. And paying for questionment on the grounds of the decisional proceeding. So, for my instruction, first time I will obtain instruction.
Because I have reserved some judgment regarding this.
Yes, sir.
Lordship, and the disciplinary proceeding, the order is pronounced, Lordship.
Yes, yes.
That is at Annex 2, Lordship.
Issue notice. Issue notice, we get.
I've also gone through your judgment.
Issue notice. Yeah.
Item 13.
311 was rejected, my lord.
But the notice was
138 NI Act, my lord. What happened in this case, my lord? Petitioner and the
Yes,
OP
yes, I have, Mr. Das, I have issued notice. Let us see. He's speaking, sir. Yes.
obliged.
my lord, the petitioner and the OP number 2, sister-in-law
Petitioner?
and the OP2,
Ah.
sister-in-law,
Sister-in-law. Who's sister-in-law?
petitioners.
Petitioner.
That is 138 check bounce 5 lakhs, your lordship. 311 was rejected. Lordship, may I issue notice so that matter can be settled because
No. You had issued check.
that is the allegation.
When was the complaint?
Complaint, my lord, 2016. One single opportunity, my lord, 69/2023, which are fixed for cross-examination.
No. Where is the complaint copy?
Complaint copy I have not.
Not filed anything.
The 11% is also not go.
311 petition is also not there.
That I give.
What's the check amount?
10 lakhs.
How much you have paid so far?
No. Relation, both are relation to each
That's
other.
right, 140
And Lordship, may see
143 capital A.
the Annex 2, Lordship, counter case. See, he also issued, her husband of the OP number 2 issued 90 lakhs check to this petition.
But you at least give the complaint copy then.
Yes, that's right.
Complaint copy, 311 application, nothing is there.
Both I will give it.
Oh, how to go about it?
Only no. We will settle it. If Lordship will issue notice, and in the meantime,
I thought that you would be settling.
relation both are
Simply issue notice to us. Issue.
Item 14.
well, IA is there.
I is
Adjournment.
there without anything.
Well, adjournment.
Without a complaint copy, without anything. No. You at least file the petition at least.
Yes, my lord,
I don't know
that-
what is the case? See,
Otherwise, 311.
these are 138
yes,
cases.
yes, that's true.
2016 it is pending.
My lord.
Very
Only
good.
thing is only one.
Whatever, then if you want to argue on that, you file the entire document. I'll put it next. I have to be satisfied.
Well, next week, assume I will file in the meantime.
Simply put 8 items. That's 13 there, na?
Yes.
Mr. Mansingh, General Counsel for the petitioner, seeks an adjournment to file additional documents which are currently in this case. Please let him do so within a week. Please be matter next week.
Obliged.
You file the entire document. Let us see what.
That's
14.
I pray for 1 week after, my lord. I pray for 1 week after, my lord.
Adjourned on request.
15.
This is a case one where the present petitioner was a junior engineer and he was serving in the Department for Water Resources, my lord.
Yes.
On 28/1/2006, my lord, 2016, my lord, a raid was conducted in his case, in his house, my lord, and he was arrested and charge sheeted for commission of offences under section, my lord, 7, 13(2) of the and 31D of the Prevention of Corruption Act on the ground of taking illegal gratification. On the same day, raid was conducted and the property was assessed. And my lord, on the basis of that assessment, now after 8 years, my lord, now after 8 years, my lord, they have lodged a second affair stating that I have a disproportionate asset on that day. I passed the trial. I got acquitted, my lord, in that case. For illegal gratification, I got acquitted, my lord. For the self-same affair, my lord, another affair was lodged after 8 years. A raid was conducted on that day, my lord, on the basis of the taking bribe, my lord. On that day, they calculated and they probably found they didn't found probably when a disproportionate asset. Now, after 8 years, my lord, after acquittal in that case.
Okay. Let us see the acquittal order. What?
Yes.
In the raid case, you have been acquitted. Huh?
Pardon?
The raid case, you have been acquitted.
Yes.
Yes, my lord. That is my lord.
Epilogue is last page 60.
Page 60.
Yes, I'm.
Epilogue, my lord, the evidentiary evidently the circumstances are link after link as depicted herein before stand squarely unsucked through inconsistent and unreliable evidence led by the prosecutions to show the window of
Yes, Mr. Marana, there is no legal bar, but how will you?
The thing is that he has been acquitted in PRAP case. So far as the DA case is concerned, we conducted inquiry. After inquiry, so many documents are
after that nothing.
process. And
When the FIR was registered? After
DA case
acquittal?
was registered
In 2020.
on
In 2024,
25/2/2024.
Okay.
After the acquittal?
After that, maybe
No.
he has been acquitted in one case. He might be acquitted in
Because
so
he
many
got-
cases.
That's right, but why have you waited?
Yes.
Disproportionate. What is the check period?
Check period is the entire service period.
You just tell me when you started this preliminary.
Not entire.
no, my lord, not enter service. No, my friend has not seen, not enter service period. That is from 280 to 89 to 2016. On which affair was lodged, and on that calculation was made. And 8 years after, my lord, again another affair.
From the date of search is the check period.
Date of search.
The end of the check.
Date of search is again.
And
Date
the
of
question is, why have you waited for 3 years? After the acquittal, you registered another.
8 years, my lord, not years, 8 years, 8 years.
8 years.
You filed reply.
I filed the bracket. So Supreme Court judgment is that it will be 14 years. After 14 years,
That's right, but you can't, you registered a trap case.
my lord,
You could not prove the case. He got acquitted. After 8 years, you file another case.
No, no,
What is-
no.
Yes,
If
exactly
trap
that.
case has
Then
no
you
next-
just tell me when have you initiated the preliminary inquiry insofar as the DA case is concerned.
DA case is from the date of trap.
Show me that you
Means
file the file.
Only after that we can conduct the inquiry.
Chat period time से लिखिଛନ୍ତି
Trap is acquitted now.
ट्राप एक्विटेड है लेकिन ट्राप डेट रे जो मटेरियल हम पाइलु सर्च करी था घरु बेसिक अपन दैट मटेरियल वी मेड फर्दर इंक्वायरी
for 8 years.
whether
That's what I want to know. When further inquiry or you
Further inquiry kitchen.
shut your eyes for a longer time after immediately after inquiry you raise it.
No, no, simply-
That's what I want to know.
Yes, ma'am. Your lordship is
File
right.
reply.
Your lordship is right.
Sequence you give me.
Yes, ma'am.
Sequence you give.
I'll give.
Yes, is good. Yes.
तो एंटर से इंक्वायरी फाइल दा
And you get the diary,
I-
case diary. Get the case diary. Call for case diary, issue notice. Mr. Marana, accept notice, wait notice. No?
Trial will not continue, my lord, because if they may also start the trial they start again.
No, I don't know. Investigation is going on. Charge sheet has not been filed.
Your lordship may pass that order if they will start the trial
Let-
petition.
See, I can't say the investigation.
No, no, I
Let us
don't.
see. Let us see. over there.
फाइल ही नहीं
Charge sheet file any kichhi nahi. Only they have registered an FIR. They may close it also. Who knows?
Bro, I open conversation close koriya pai. Kain bhala sei kale setme korchun.
You have not satisfied someone. You should have satisfied someone. You didn't do that. What to do? Therefore, the second FIR. Yes. Yes.
60.
May I beg your question? My lord, the order of taking cognizance is under challenge. And while the entire case is of in civil nature, the London court should not have taken cognizance of the offence punishable under the Indian Penal Code, my lord. Fact is that the informant lodged a case against the present petitioner, alleging that he takes some money, entire amount is 1 crore something. The petitioners paid 61 lakhs towards part payment. Thereafter, he made a power of attorney to execute everything on behalf of the informant. While this situation is going on, the original owner of the land, he made a permanent injunction regarding on that plot. For that reason, the petitioners could not sell the property to the persons.
Show me the charge sheet. Where is the charge sheet? Show me the charge sheet.
My lord,
Only FIR has been
I'll-
filed. Facts remain. they have
Give
taken-
me give me the charge sheet.
Well,
Cognizance order you are challenging. Very. I
I'll
need to
file.
know this. Not filed.
I'll file it, my lord, by tomorrow.
By tomorrow, let it be
By tomorrow, my lord.
after 3 weeks. File the charge sheet. File the charge sheet.
My lord,
Cognizance
my lord.
order you are challenging.
My lord.
Yes.
70.
The matrimonial dispute in between petitioners number 1 and his family. With the petitioner number 2, my lord, the challenging
Matrimonial dispute. Issue
the FIR,
notice.
my lord.
Yes.
15.
My lord, 18, I did my pass over on behalf of the
19.
Please, Your Lordship.
Yes.
Your Lordship, the present petitioner has challenged the summons that has been issued to him on dated 14/6/2024. That is at Annexure 1, Your Lordship. On the ground that, Your Lordship, for the self-same allegation, he has already faced a full-fledged trial and has been acquitted from that, Your Lordship. And despite that, a summons was issued to him, and he had also taken an anticipatory bail from this Hon'Ble court. In the anticipatory bail, Your Lordship, it was directed that as and when required, he will appear before the investigating authorities. Now the predicament is that, Your Lordship, on the pretext of appear as and when, he is being continuously called, and the documents also he has produced. Still then he is being called, Your
How
Lordship,
can I
and
stop?
for nothing.
How can I stop?
Lordship, but that is what is
You may be required. I don't know.
yes, Your Lordship, that
And
is
you are protected by this court order anticipatory bail. If someone has been issued, go and appear. What is the big deal?
we are appearing. That is what
You-
I'm saying, Your Lordship. Your Lordship.
Never appeared.
Your Lordship, that is what is given on the affidavit.
Wrong submissions have been made.
Hmm.
In the schedule offense, this petitioner was convicted, filed an appeal. It's a different question. After repeated summons, he has never not appearing. Some plea or other matter is being adjourned. Your Lordship, kindly see the anticipatory bail order, what my friend said. When earlier summons were issued, they filed the anticipatory bail application. This court and sir, your Lordship, kindly see page 16.
Yes, there, I'm there.
You that it open to the person to search, to take such a stand before the authority, we said we will be considered. They said document has been seized by the EOW. He can go and say that.
Your Lordship, that is what I am saying, Your Lordship. Your Lordship may look to Annexure 3 series, where there are a series of names, Your Lordship.
Yeah.
And the fact that the petitioner is not appearing, that is wrong prima facie
So,
because
madam, the problem is today if I interfere, it is tantamounting to regulating the investigation process.
Lordship, that is what I am saying, but I cannot, a sword cannot be kept hanging on my head forever. I have been convicted of that offense and appeal is pending. I'm on bail and I'm cooperating. I am going to the ED office. Let them say that I have not gone and not cooperated.
Do it, see, I can't regulate him.
Yes, Your Lordship, we are not seeking for any regulation, Your
What do
Lordship.
you want? Someone I can't pass because you have to go.
Your Lordship,
Because you are convicted by this
Your
court.
Lordship, we are anyway doing what our
So what do
stand,
you want from this?
Your Lordship,
company?
what our stand is that the document that they are seeking, Your Lordship, those documents have already been seized in one case and they are already in the respected courts of law, Your Lordship. So that is my predicament. I will not be able to produce those documents anyhow, Your Lordship, except the judgment of that case, Your Lordship. So continuously calling me and making me sit for hours in the ED office, Your Lordship.
Give me, show me the date
Yes, Your
chart.
Lordship, yes.
Show me the date chart. How many times you have been called? Let us-
He has been.
Your Lordship, Your Lordship, I have gone. That
Give
is
me,
the,
give me.
Your Lordship
me
may
dates.
look into Annexure 3 series, Your Lordship,
Yes.
17 to 22.
Yes. You are requested to appear.
Appear.
Yes, Your Lordship.
Then the
You are
next page
requested to
also,
appear.
requested to appear. Then the next page also.
Whenever you appeared, you
Your
said.
Lordship, the reply is at the down, the reply is at the
Yes,
below part of the
I
page. Your
swear
Lordship.
so I tell that I go to Cuttack to receive the certified copy. It's my.
And submitted.
All ego issue. It is all-
Lordship, where are submitted?
He has never appeared, my lord.
See, how can I go into all these things?
Your Lordship,
He-
find
he-
a-
See, 482 courts are not meant for these things, you know.
We have already shown.
The only option is the court has to go and sit there.
No, Your Lordship, that cannot be done by the.
And attendance.
No, Your Lordship, that.
Then why 482 courts are not meant for all this?
Also-
What documents I have called at page 13.
13, 1, 3.
Hmm.
Okay.
Page 13, 1-3.
Hmm.
Aadhaar card, PAN card, voter ID. Detail of movable property held in the name of a family member yourself. Detail of bank account, so and so, deposit held. These documents, he cannot say Aadhaar card I don't have.
Your Lordship,
He can-
Income tax return and
Your Lordship, that is what is our same wrong, Your Lordship. The same documents, Your Lordship, because I was involved in the case pertaining to. Let me submit, Your Lordship. All these documents, Your Lordship, they have been, because.
when are you going to appear, you tell me. I'll record that and finish.
Your Lordship, like, if you I'm going that way.
What do you want?
Let him know.
When?
Every day, my lord.
You tell me when
Next week, Your Lordship.
next week.
Yes, Your Lordship.
Petitioner has invoked the jurisdiction of this court under 482 CRPC challenging the summons dated 14/6/2024 issued by the investigating officer to appear before him. It is contended that the petitioner has already been protected by this court by the order dated 22/7/2024.
That will not I dispute.
ABPL.
Because in ABLPL, no order was passed. ABLPL, because that someone was challenged, and when we objected, then he said, I'll take appropriate measure. Lordship, I'll see the page 16 of that order.
Yes, someone was challenged.
Someone was
Right,
challenged.
right,
in the-
okay. Continue.
Someone is not challenged, Your Lordship. On the basis of summon, I was seeking an anticipatory. And
Earlier, petitioner approached this court by filing ABPL number 7018 of 2024 after receiving the summon dated 14/6/2024. Same summon.
yes, Your
Same
Lordship.
summon, Your
The same summons. Your Lordship, or else
No,
may I
no, no.
make a prayer, Your Lordship?
The coordinate bench of this court by order dated 22/7/2024.
Before
Inter alia passage following order page 16 paragraph 4. The petitioner has now challenged the same summoning order by filing the petition. And the Mr. Agrawal appears for the respondent on advance notice and submits that the petitioner has not appeared before the investigating officer pursuant to the summon issued by pursuant to summon issued, rather approaching the court repeatedly. He submits that pursuant to the order dated 22/7/2024, it is open for the petitioner to appear before the IO and point out grievances he has. The counsel for the Mr. and counsel for the petitioner submit that he is not averse to appearing before the IO, but repeatedly calling the IO or repeatedly calling the petitioner to submit documents which are not under his custody. He is nothing but an arrogant. He submits that in the predicating offense, his client her client has already been convicted and the appeal is pending, and all the documents are in the record of the said case. Therefore, he is not in a position to furnish the document. Be that as it may, I am not inclined to fail to by entering into the controversial facts. However, suffice it to say that the petitioner shall appear before the IO on next week.
Yes, Your Lordship.
Friday, let it be Friday.
Next Friday, Your Lordship.
Friday.
10th.
At 10 o'clock.
10 o'clock.
10 o'clock. And submit 11 o'clock. 11 o'clock, and submit the document which are under his custody, and the rest of the documents which are not in the custody, he has to specify the same before the IO, and the IO may venture the same in accordance with law. With this observation, the petition is disposed of. You appear on that and tell whatever you have, give the list. Yes.
Criminal appeal. I have filed a memo. If we have filed regarding rejection of 44, now we want to withdraw that appeal.
Which was?
I have given a memo that.
List tomorrow. Withdraw list.
Much obliged, Your Lordship.
Tomorrow, take the memo.
Criminal appeal 549 to the date in memo.
Monday, Monday.
Much obliged, Your Lordship.
And appear on that day, whatever the list is there, whatever documents are in your custody, you give it. The rest of the document you tell.
Okay, he can also give a petition that these documents are
not there,
time
simply.
seized. But he is avoiding to appear before the IO.
I have to fix the date now. You go.
Yes, Your Lordship.
20.
My Lord, I'm seeking for a 2 weeks adjournment.
Let them all be clear. Yes.
21.
Wait, please. Your Lordship, this matter may kindly listed along with 4240 of 2024.
They connected.
Connected, Your Lordship. Because both are the same related matter. If Your Lordship.
Related in the sense arising out of the same FIR.
No FIR, same not FIR, same persons are there.
Person may be.
My Lord, because NBW order 80 को आसे वो समाने से cases solvent रही परिवीन.
This is NBW.
NBW, my Lord.
I'll quash it and
that matter also pending, my Lord. Sombar should be there.
No, in both the cases NBW.
NBW is there.
Please next week. Give the number.
Well, I will.
I'll quash NBW go and appear in both the.
It will go the outside of the list. It will go through the.
Okay. NBW go.
22.
May it be your Lordships. The compromise matter, Lordships. Kindly see the order dated 19/12/2024.
19/12?
2024, Lordships.
Of this court?
Of this court.
1912. There is no 1912. Item? Who item?
22 year also.
2512. 2511. 1912.
1912.
Yes, you please.
Your Lordships, on that day, our Lordship victim appeared and filed an affidavit. He is will to marry another boy. He has marriage, her marriage has been.
That I understand. The statement is on. The statement.
Noting that affidavit is tagged at AG.
I'm waiting for the victim.
No.
Affidavit has been filed.
Yes, what is it?
The affidavit has been filed, that affidavit may be sought down. The copy has not been sought.
That already.
No, the informant, see, the informant has now filed an affidavit.
Yes, ma'am.
Saying that my marriage is fixed somewhere else.
Yes,
If this case continues, then I will have a problem. I had relationship with this petitioner.
Yes.
This is what she says. So I issued notice to seek instruction. What is this case?
Last submission, your Lordship wanted presence of the accused.
Accused, yes. Accused was not there. He is now on bail. He's there. What is this case?
Charge sheet has not been filed.
Not filed. I'll quash it. What is this?
Yes.
If I'll not quash, what will happen, you know? The
I understand.
marriage of this girl will be at stake. Unnecessary, why to create? Right. Where is the accused? Accused is that. Last order, 19th order. Petitioner is FIR number bonds. Alleged to the petitioner's bonds. The simply. So the petitioner is seeking quashing of the FIR. Now that he has settled with the victim got. Investigation of the presentation still. The matter was taken up for hearing on 25/11/2024 and the following order was passed. Pursuant to the aforementioned order, the accused has been enlarged on bail. When accused was enlarged on bail?
Pardon, Lord.
When he was got bail?
Bail.
19th.
Enlarged on bail on 19th of this month, huh?
Yes, 1912.
December 4. The accused petitioner is present in person today, being represented by his counsel and identified. Has he filed any affidavit, anything? The victim in the present case, who had already appeared before the court, had filed an affidavit on 25/11/2024 inter alia stating as under para 2, 3, and 4. Para 2, 3, and 4. Regarding the fact that the victim is not willing to support the prosecution, and she has very categorically stated that her marriage has already been fixed. If the case continues, the marriage, the marital life of her marital life would be marked. She doesn't want to proceed against the petition. In the fact scenario of the present case, subjecting the petitioner to the rigors of the trial would be a futile exercise, as we prosecutor herself is not supporting the prosecution. Therefore, this is a fit case for interference. Interference as the same is covered, the case of the petitioner is covered by cost case.
Much.
23.
23 on behalf of Mr. Mahapatra, I'm praying for adjournment.
Adjournment.
Hello. It's a similar small offenses, my lord. 420, 323 matters, my lord. Civil disputes are there. They related to criminal case.
Will you argue or
No, my lord. I'm for
on
your
behalf
lordship's
of
kind.
Mr. Mahapatra, Learned Senior Counsel, Mrs. South seeks an adjournment. Release the matter after 2 weeks here.
Grateful. Your lordship.
24.
May I please, your lords? Petitioner, present petitioner is the complainant in court below. Well, the limited phrase to conclude the trial within a specific.
What is this case? Is 138?
138. 130.
Right. The present petitioner is the complaint in ICC case number 135 of 2019, initiated by him against the opposite party for the alleged offenses, punishable under section 138 NIA. 138 NIA. The petitioner, being the complainant, agreed by the fact that the matter is pending. The complaint case is pending since 2019 and 2019 under section 143 clause 2 of NI Act. The statutory mandate is to conclude the proceeding complaint under 138 NI Act within 6 months. 6 months. Hence, he submits that the appropriate direction may be issued to the trial court to conclude the trial. Next paragraph, the prayer made by the petitioner deserves merit. Accordingly, the letter of SDGM Jajpur is directed to do into see that the trial of ICC case number 135 of 2019 is concluded as successfully as possible. Yes.
Okay.
25.
May it please, your lordship. Simple matter, your lordship, with the complainant filed 138 application before the learned court below in the year 2017. After proper trial, my lord, on 9/12/2022, the accused convicted. The accused preferred one appeal on 27/12/2022. Since then, my lord, the matter is pending for hearing because of the non-cooperation of the appellant, my lord. Convict. My lord. I am the complainant. I am before this honorable court, for your lordship may kindly target this matter.
Why have you moved application under 148?
In the appeal, not moved. Your lordship.
Then you move application. At least you get interim compensation.
Your lordship, may kindly come to the last order of this one, the learned court below one. The learned court below directed to deposit the amount.
Where is that?
20% amount.
That is 148. It is not deposited.
Not deposited, my lord. He is lingering the matters. That is only yours.
So what do you want here now?
Your lordship may kindly target this matter so that
If he is not deposited, his appeal is will be dismissed.
the learned court below not dismissing that matter also.
That is a precondition.
My lord.
That is a precondition. I'll just record it and dispose it up.
Without target, my lord, the learned court below will.
Why should I target if he is not compliant 148? It will be dismissed automatically. If I'll target them,
because my lord,
then
the learned court below granted bail.
See, it is not in your interest, I tell you.
My
the moment I'll target it, he'll ignore the 148 and proceed with the appeal. Why are you inviting that order? Suppose I'll target it, the 148 order for interim compensation which has been passed in your favor, he is not depositing.
My lord.
The court will say that since the High Court has targeted, I'll dispose of the appeal. Then your 148 is redundant. Why are you doing that?
Your lordship may kindly have this matter, I will take instruction whether what is the
instruction you rather you withdraw it, saying that you move appropriate application for insisting him to deposit for 148. Otherwise, you move an application for dismissal for non-compliance of 148. Appeal will be dismissed.
I have only the last order dated 16 July 2024. After that,
Put next week. You tell me, otherwise I'll dispose it with that observation.
Good.
You move an application there saying that
I have already moved application, my lord.
For dismissal of the appeal for non-compliance under of 148A order.
I will not move.
That you move. I'll record it and dispose it up.
My lord,
next week.
Great.
26.
Please, my lord. My lord, here, my lord, the complainant filed a complaint petition under 139 NI Act, making an allegation that I have issued a check of rupees such and such to alienate the property. Only to avoid, because I have also demanded the rupees 8 lakhs, which he has taken from me, but he has not repaid that said amount. Only to avoid the same, only deceived me that one check has been issued, taken from me, that he to avail the bank loan and repay my dues of rupees 8 lakhs. When I repeatedly call him that to repay my 8 lakh rupees without any interest, but he has filed a complaint case against me here at Tangi, which was also registered as 1cc case number 46 of 2024.
Where is the complaint copy?
Complaint copy, sir, I have given for us.
Where is that?
That is there.
Show me the
That the complaint petition copy, extra copy is also with me.
Yes.
Can I give it, sir? Yeah.
Yes. Show me the statutory notice that this is at page
Yes.
40.
Sir.
Page 40.
Sir.
Page 40.
The only thing, sir, the law and my says is very hurriedly try to dispose of the matter. When I am also ready.
Because the statute mandates that it should be.
That complaint case, sir, is yet 24. He has filed a complaint.
Just before your case, another case, the complainant came saying that the magistrates are not doing any job. In your case, magistrate is doing a good job. You should be happy.
No, good job, that's all right. But what happened, we are sought for an adjournment because you want to place all the documents. Matter can be decided either or. By the before.
Shall I expedite it?
No, not required expedite.
Then what do you want?
Only record may call for here.
No, I will not call. 138 is in a trial stage. Why should I do all these things?
Otherwise, allow.
You satisfy me that there is no case made out, then
Already that is in the course of trial, no case has already been made out by the complainant.
Show me.
Sir,
Understand what is the case.
Sir.
You have admitted the fact that you have issued a check.
No, I issued a check, but he has also taken the check to avail the bank loan to repay my dues.
Those things are factual dispute to be sorted out in the trial.
Please see the course of trial. He has failed to made out a case against me.
You want me to appreciate the evidence which has already been recorded by the trial court in a 482 proceeding when the trial is going on?
Sir.
I can't do that, sir.
Only, sir, one prayer is there. Allow me to adduce my evidence. Adduce my evidence.
The trial court has not allowed you. Show me.
Already the one that miscase I have filed, sir. I have filed a miscase that I have sought for.
Please concentrate in this petition. What are you seeking in this petition?
Only seeking that.
Where is that? Well, show me. Where is that?
That is to quash the cognizance. My lord, in miscase I have filed that the petitioner have placed that in view of the submission made above.
Sir, cognizance order. Why are you challenging cognizance order if evidence is going on? Evidence is concluded now.
Because only, my lord, the evidence is concluded in absence of allowing.
That's what I'm saying.
Yes, allowing me to produce the documents. Let my document to be accepted.
Has the court denied you? Has the court denied you?
Yes, he has denied.
Show me that. That's what
he has already, sir. He has already concluded the trial. No, denied me not to accept any evidence from my side.
Show me that part. Where the trial court has said no, you will not adduce evidence.
My lord, in I have filed an IA that I have clearly stated. IA.
Yes.
The complainant is so para 3, para 4, sir. From the above said discussion, the complainant failed to prove his case
beyond reasonable doubt about the issuance of the check by the petition in absence of any transaction of the alienation of the property, a blank check purportedly misutilized by the complainant. That it further stated that the trial court proceeded with the trial despite the request made by the opposite party to adduce the.
Where is that request by way of an application? What?
Yes, I have a file an application.
Where is that application? Show me.
The application.
And what is the order made in that application?
They have not accepted my application, sir. This
thing I don't. He has not accepted your application.
No.
You are challenging the cognizance order. What is this?
Cognizance order is a challenge,
It's
but
completely frivolous petition.
No, we have challenged the cognizance order because he has failed to made out a case against me.
Your grievance is the trial court is not allowing you to adduce evidence.
Yes.
Is your grievance?
Yes, sir. Yes,
You show me whether trial court has denied you,
Yes,
or have you moved an application which is rejected?
Sir.
You are challenging cognizance order here. Why are you not focusing the case? Where you are aggrieved? You show me, I can give some indulgence.
Sir, this is the letter issued to the complainant from me.
What will I do with the letter, sir?
Only to peruse that letter, sir.
I know you have evidence, sufficient evidence.
Sir.
You want to bring on record. I understand that.
Sir.
But have you approached the trial court?
Yes, I have, sir.
Show me that.
I have, sir.
Very interesting. You have kept everything on your.
No.
I think you have not prepared.
No, I have prepared, sir. I have prepared. Only that the document is.
Can I keep it next week?
No, not next week. Can it be taken up Tuesday?
Tuesday is next week only.
Tuesday, sir. Tuesday.
Okay, next
Sir,
week.
sir.
You focus it.
Sir.
And place on record which
Yes.
are the application which you have moved.
Yes.
And what is the order made in that application?
Yes. He has not accepted my application, sir.
I understand it.
Yes.
Move that application. Tell me.
Sir.
Which is the application you moved? What is the order passed?
Sir.
Tuesday. Okay.
Sir.
Okay. Don't bring all this and show me.
No.
Highly.
No, pertinent things I have
Yes.
also brought it to my lordship's
Yes.
notice, sir. Only.
27.
May I please, your lords?
Yes.
My lord, the appellant has been convicted for commission of offense 409, 420,
What is the sentence?
My lord, 4 years substantive sentence which runs concurrently, my lord.
Are you on bail or
My lord, he is in custody, my lord.
custody? Okay. Bail granted. Bail granted. Appeal admitted. Bail granted. Realization for the fine amount in state and call for TRC.
CBI is the opposite party.
So, 4 year sentence. I'm suspended. Yes.
LCR में क्या?
I have got. I don't use the word LCR. TCR. No court is lower. Every court is same. Yes.
28.
May it please your lordship. My lord, the petition was released on bail during investigation. My lord, on dated 17
Bail 11/10/96. NBW 17/9/24.
24.
Your lordship may peruse the order of which you have challenged.
I have allowed, sir. I have allowed your plea. I have allowed you. Yes.
29.
Belgium case.
Yes.
Bail 1/12/3. NBW 28/10/24.
Okay. 500 each. Yes.
The two petitioners.
20, 500 each. 20th January कर दो. 20th January. Okay.
30.
May please your lordship.
30.
Passing the order of.
Yes.
May please your lordship. I am seeking to quash the NBWA order dated 18/4/2024 of Learned Jain.
NBW 18/4/2024 है और FIR देखिए. Okay. Allowed. 500.
31.
May I please your lordship, my lord, NBW order issued 5/8/24, earlier on bail 12/8/24, my lord.
12/8/24. 40. Okay, 500. Yes. Yes.
32.
Yes. 32. Non-appeals for the petitioner. Please the matter. Simply urgent. Yes.
33.
33. Petitioner is in custody since 14/4/2023.
14.
4/4/2023.
23. Okay.
Yes.
Yes.
20B2C of the NDPS Act.
Recovery.
Recovery 150 kg, 995 gram. Not from the conscious possession of the petitioner, because he was the
20 kilo.
No, 150 kg, 995 gram.
Yes.
My lord, about 9 charge sheeted witnesses, 19. Out of 19, only 2 has been examined.
19 charge sheet.
Yes. And out of the 2, my lord, last time I have shown your lordship, the statement made by one of the witness was present at the spot. Actually, the vehicle met with an accident. Petitioner was not arrested from the spot. He was at about 200, according to the about 100 to 200 meter away from this vehicle. And from the vehicle, it was seized. He was not in the vehicle.
How many cases are there against?
No case is there. And I, as per your lordship direction, I have filed an affidavit at flag D.
Yes, that time.
So my submission before your lordship is that since in the meantime about 2 years is going to be passed and I am in custody and nothing has been actually in view of the evidence, nothing has been seized from the conscious possession. If your lordship, I have last time also I have shown to your lordship one portion I am just reading out.
Portion from charge sheet.
No, evidence.
Evidence. Whose evidence?
That is one of the constable, PW2. And last time I have shown to your lordship.
Yes, Mr. Jana, 2 years. Ravi Prakash.
And your lordship has also directed the trial court to.
I have sought a report.
From that, he has also filed the affidavit as per your lordship.
Yes, this is the evidence of
1 and 2. 1 and 2, only 2 witnesses. 2 is one of the constable.
What is your name? Your name is
Bhim Singh.
Bhim Singh. I apprehend the accused personally who have accused was apprehended to construct this the vehicle was placed open at the spot of the street when he was from the spot you have been not arrested.
No, not from the spot. I was, my lord, as per their own statement.
Right. Petitioner is accused in so allegations. The petitioner is in custody since 14/4/2023. This court sought for an wide order dated
As per affair story, my lord, he was in the spot, my lord, and
but the evidence is otherwise.
Evidence of
Wide order dated 22/11/2024. This court sought a report from the trial court regarding the status of the trial. Persons to the said order, the learned sessions, listed in sessions it's letter dated 25/11/2024. Furnish the following report. Report okay. Following report is following report. Mrs. Sugata Jena, learned counsel for the petitioner, submits that out of 19 witnesses, 2 witnesses have already been examined. She has emphatically relied on the testimony of PW2. Who is he? PW2?
Is one of the constable.
One of the official witnesses, who is accompanied with the investigating officer. He, the witness, inter alia has stated the agenda. For para 8 9 relying upon the testimony of the PW2 learned counsel for the petitioner submits that it has come on record that the petitioner was not apprehended from the spot. So therefore, the ganja 150
kg, 995 grams.
950. So ganja recovered from the spot is obviously not from the conscious position of the petitioner. Conscious position of petitioner. Mr. General and Counsel for the state opposed the grant of bail in view of the huge quantity of ganja from the spot. However, the evidence which has come on record indicate that the ganja so seized is not from the conscious position of the petitioner. Prima facie issue, petitioner is in custody for more than about 2 years. About 2 years. Out of 19 witnesses, only 2 witnesses have examined. The trial is likely to take considerable time. Therefore, relying upon the judgment of
Ravi Prakash
also, Jana submits that the petitioner is entitled to bail. I am in fully agreement with the submission made by Mr. Jana. Accordingly, I allow the petition and grant.
I have opposed the
And that is obvious. And the petitioner has also filed an affidavit dated 2/12/2024 inter alia disclosing that he has a clean antecedent and he is not involved in any other case. Subject to verification and all. Yes, sir.
I will pardon. 32 the mulli royoli.
Oh, I'll just pass over. Pass over.
Next week no le.
Okay, next week. Okay. 34?
Yes.
18 will come. Pass over. Pass over. Yes.
So, you know, she will add that matter. Since POXO is there.
Let's see, 2 o'clock. I will be in a better mood.
I'm filing my Uklatnama, Lordship. I'm filing my Uklatnama and deposition copy of a P5. P5.
Petitioner.
Yes, petitioner.
Petitioner. Maybe you may file it there. You have to file it there and list it next week.
Tomorrow.
Next week.
Next week.
File it.
Pardon, my lord. SK Jafrula name may be deleted. SK Jafrula name may be deleted.
Name of so may be deleted. List the matter.
Yes. A copy would have.
Yes.
35.
May I please, on behalf of Mr. My lord, Hon'Ble, my lord. But in this case, my lord, last of the urgent this case, my lord, you don't matter. Charge sheet submitted, preliminary charge sheet submitted on some 420, 408, 461, 468, 471, 120 of IPC, my lord. Petition in custody since 9/5/24, my lord. 9/5/24.
Yes.
And charge sheet submitted on 3/9/24. Preliminary charge sheet, my lord.
39.
My lord, 3/9/24.
Yes.
And offense 420, 408, 461, 468, 471, 120 of IPC, my lord. But in this case, my lord, admittedly petitioner working under the informant as a accountant, my lord. He resigned from the service on 2018.
You implead informant, I am issuing notice.
Already appeared, my lord. Appeared. Okay. And what happened in this case, my lord? He resigned in 2018, my lord. 2020, my lord, the informant is working under
the amount involved.
Informant, they have not substantiated in charge sheet, my lord. They have stated that
What is the amount involved?
2 crores and something, my lord. But in fact, my lord, that has been, my lord, payment made to the parties, my lord, through RTGS and other check and other processes, my lord. And no online, my lord. Nothing come to the account of the petitioner, my lord. Only 2 lakh something, my lord, that is self check to the petitioner, my lord, when he was accountant, my lord. That is the salary of the petitioner, my lord. And except that they have not substantiated anything, my lord. They stated that the petitioner might be for the signature of the informant and related things, my lord. That is online transaction, my lord. And they have got the instruction from the earlier, my lord.
What happened in this case, my lord? Present petitioner is the accountant of the company, my lord. He is dealing with all the financial matter, my lord. From 2015 to 2018, my lord, what he did, my lord, by forging the signature of the MD, my lord, credited some amount to his account, my lord, and others, my lord. Yes, just wait, my lord. I am, my lord, filing 2 account sheet, my lord. One is, my lord.
You file an objection.
Yes.
You file an objection.
One is, my lord.
Next week, 1 week. 1 week.
No,
because there is no paper here. You file it. File an objection, whatever objection.
My lord.
File objection. List it.
My one thing, my lord. Though my lord charge sheet submitted 3/9/24, my lord.
Investigation
Keeping open for the signature, my lord, whether signature is forged or genuine, my lord. My signature, informant signature, and those accounts that money gone, my lord. Their signature
Send it to
my lord.
My lord,
are you waiting for that?
And we are waiting for that, and also my lord monitor. That part also we have to ascertain because
She is the IO. What is the stage, ma'am? Okay, are you expecting the handwriting expert report shortly?
My lord, in that.
Please, the maximum data signature confirm sir. Already sir handwriting groups comparison completed. But the party account to the guiding person, not person would say party examination the state is signature they are not.
केबे आपण एक्सपेक्ट करछुनी पाइबे आपण रिपोर्ट ता
केबे पाइबे आपण से
रिपोर्ट पाइबार एक्सपेक्टेशन के 10 दिन परे रखिबा
केते दिन
10 days
ये 2 weeks कोचन देगा
नहीं
he is saying that he has to ascertain from the handwriting.
What is his role? Just tell me. I'll put it next week. Next week you file the report.
1 week after us.
Another thing, my lord. My lord can ask the IO, my lord. They have, my lord, filed the returns, my lord, each and every year, my lord, and balance it also. Not only to the income tax department, but also the company, my lord, secretary company, my lord, registration of company, my lord. They have also filed the balance sheet, my lord. How, my lord?
The company.
The company, my lord, the private company. But they have filed the IT each and every year, my lord, and a balance sheet before the, my lord, registration of company.
I'll tell you, Mr. Ragada, the problem is if an intelligent accountant does all these things, nobody
No, my lord, because
nobody can catch. And when an intelligent lawyer defends him, then he's bound to be
actually, my lord, that part
is dealing with the
I am maybe, my lord,
Mr. Das is also agreeing with that. So he will be acquitted definitely. But the only thing is when he's going out in the bail, that is the punishment.
After my resignation, all these things happen, my lord.
Get ready to pay the money sometime.
My lord, 2 lakh something came to my account, my lord. That is my salary, my lord.
Whatever.
The IO, my lord, the IO is here, my lord. He failed to substantiate the allegation, my lord.
What are the amount which has been transferred to your account?
2 lakh something, my lord.
2 crore 35 lakhs.
No. From the company account to your account.
Not only
in his account.
No, my lord, that is not correct, my lord. That is not correct, my lord.
Document, my lord.
That is the company account, my lord. No, not my account.
Your personal account. I'm talking about his personal.
Personal account 2 crore 35 lakhs.
No, that is not.
From the company account, my lord, 2 crore 17 lakhs.
That is not correct, my lord.
She will ascertain it.
That is also investigation.
A petitioner.
Account sir, based withdrawal 2 crore something sir, withdrawal by sir, sir, there is no result out. You guys are already in further money.
But the charge sheet, my lord, they are submitted, my lord, nothing there, my lord.
Keep it a week. You file.
1 week after the answer, file करता
Last chance, they
already in the custody for
9/5/24. 420 offense, my lord. Trial all the offense, trial master.
get ready to pay some money.
But that is true, my lord. They substantiate, then only, my lord, I pay some money. 14,000 salary.
What have you recovered from his house?
No, nothing.
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 Then monetary under.
Neither no, my account nor my lord.
Open for that reason also.
All these things, my lord, will be done by the, my lord, the informant himself, my lord.
We'll see.
He's a builder, my lord.
Who?
The informant. Builder, my lord. He cheated some persons, my lord. In order to escape from
He may be your co-accused, don't worry.
26, my lord. Review application. And contesting party is my lord, staff selection commission. Then council engaged by Mr. Surya Patni.
Yeah.
I pray after lunch. He has engaged in another.
He is also married. Now.
Sorry?
Number 11.
Port number 11.
Number 11.
shall I pass it over?
नहीं से कहले मार पास होते
37.
Yes.
Last occasion, Lordship directed may take instruction when he will make the
Last
payment.
occasion is only urgent.
Only urgent orally your Lordship directed because page 17 on their submission that he will return the entire money, your Lordship granted bail. Now he is playing with the court, released on bail since long and not paying a single pie. And the Lordship last time specifically directed to at least pay 1 lakh rupees as per his contention. But what I have taken instruction.
Well, show me the condition, bail condition.
My lord, the page 17, my lord, kind of glance paragraph 4. On counsel for the petitioner on instruction submits that he would pay all the amount to the informant on installment basis, and to begin with, he would pay a sum of rupees 1 lakh. Within 15 days from the date of his rest of the amount, he will pay.
Yes, madam.
Yes, Lordship, I am taking instruction from the client. He wants to 3 months more than time because his financial condition is not good, Lordship.
So why have you made the statement then in the court? You made the statement that I will pay, on the basis of which you got the bail. Now you are.
Yes, Lordship.
He's playing with the court, madam.
What do you say?
Lordship, I am taking instruction that is he wants to more than 3 months time, Lordship.
No, this can't be. Within 15 days, you move application then. You have not moved the application. You came out and doing all these things. Either you move application seeking extension of time. You seek extension of time. If the time is extended, I can understand. What do you want?
Lordship, give a last chance.
Next week? Move an application in that dispose of matter seeking extension of how I can't suggest you more than what?
Yes, Lordship. Lordship, 1 week after, Lordship.
Up to 1 week. He doesn't have the money, where from he'll get?
In fact, my lord, there was a talk. My lord, he flatly denying not to pay. Since he was granted bail, my lord, and during investigation,
it is about 3 lakhs.
3,84,000.
See, either you pay or ask him to appear in this court. I see. If I'll cancel the bail order, then you will be in trouble.
Because it violated the court order.
Violated. This is an admitted violation.
Yes, Lordship.
Admitted. Just simply urgent.
38.
Come with some money. Otherwise, I'll cancel it. Okay.
38.
I beg your pardon, Lordship, I have one BC. Item number 38 may permitted to be withdrawn.
Withdraw?
Yes,
You
Lordship.
want to withdraw?
Yes, Lordship.
Yes, withdraw.
39.
While a petitioner for questioning of the proceeding on the ground of compromise, earlier one case is filed that is CLMC number 4 to the 24 minor. For the certified copy of the order is annexed minor. That's why I filed a miscase for that the copy will be dispensed with. And the list along with that CLMC number 4 to the 24 minor.
No, this is a matrimonial issue.
Yes, husband wife dispute, my lord.
But then why don't you call him?
My lord. Now, along with that, CLMC 4 of 2024 may be listed.
What happened to that matter?
That is also my notice, and one day they came to this court for subsequent when appeal was filed. Therefore, case was adjourned, my lord.
Sorry?
Therefore, the case was adjourned, my lord. Because in this petition is the husband. And in that petition, my lord, the brother-in-law and the father-in-law.
Okay. Please this matter along with us. And bring everybody.
Yes.
Next week?
1 week after, my lord.
1 week after.
My lord. That will fix one.
Along with so and so.
4 of 2024.
Okay. 4. Next date of hearing, bring them. All of them. I'll quash both the cases.
4 of 2024.
Item 40.
At 40 of the last one on the 12th, your lordship has directed me to file the requisite. But the order is uploaded as letter for which reason I have filed it today. The requisite I have already filed.
Okay.
Order is uploaded on 450.
But yeah, I told you you should have filed. Why are you waiting for?
ସେ ଅର୍ଡରଟା ଦେଖିନାହାନ୍ତି ବୋଲି ମାନେ କରୁନାହାନ୍ତି କହିଥିଲେ ଦେଇଦେବି my fault ଛୁଟିଟା ପଡ଼ିଗଲା ତ ସବୁ
The requisites has already.
today already I have filed.
Mr. Vishwal requests for the petitioner submit that he has filed requisites today for serving of duties on this matter.
Interim order is there to file adjournment petition.
The interim arrangement made by the order dated 23/12/2024 shall continue.
41.
May I please, Lordship?
Lordship, 41, we are seeking for a modification of order dated 6/12/2024.
What modification, madam?
Lordship, you have this court has directed us to pay 10,000 towards the proceeding to District Bar Association, Jaipur. Instead of Jaipur, Lordship, it will be Bhavani Patna, since it is tried before the
Last part, okay. Order dated instead of Jaipur, it's Bhavani Patna. Allow.
42.
42. Yes. Modification. What modification?
Dispose of
42, na?
dispose of case रे से उडा आई फाइल कन कॉपी दा देही ना
What modification just
देही ना
modification? Pass over. There is something. Yes.
43.
43, may I please, ma'am? Last Lordship has been pleased to direct the State Council to obtain instruction that the custody of girl child minor. Mr. Padhi was arguing that
There is
matter.
a private opposite
Yes,
party
my lord,
also.
I
Now,
mean busy.
minor baby is in
My
Yes.
lord, I'm just clarifying, my lord. Admittedly, last day I argued before my lord that a mother has taken exchange his daughter and son. She has taken a son of somebody else, who is informant, and after that, that boy is kind. Again, he came back. Police arrested him. His own child was in custody of the CWC, and CWC handed over to the Balasram. Till that, last 9 months, Balasram is taking care of. We are going and see my child, but I am not able to get back because the JMFC rejected my order, which is impugned on before my law. My procedure is that suppose anybody is under file, it should be identified properly and hand over his child to his mother.
So what is the age of the child?
6 now 9 months.
Give it to the parents.
They are the biological parents.
present petition exchange her baby into an
Whatever, the child has to be there with the natural
now,
parent.
after release that petition.
Forget about
Yes, sir.
the merit and all. The child has to be there with the mother.
That's right. That I will.
Don't go into technicality. You are appearing for?
Along with Mr. Padhi, because he is on busy.
Notice to.
Because I'm out of
7 and 8. Who is appearing for 7 and 8?
Private opposite party worship there.
Who is appearing for?
8 notice the but my lawyer file the requisite petition.
Why have you not filed requisites, Mr. Body? I should notice you don't file requisites. What to do?
Already filed, my lord.
No, not filed. That's the report.
One second, I will check it. I asked my clerk.
These are the matters you.
Order. I have filed by. I'm sorry, but
then what can I do?
No notice is issued. There is noting that non-filing that's
The 7 and 8, the child is in their custody.
Child in the custody.
I wanted
not their
so that I can
custody.
keep
Child is in
that.
their custody. His own child is taken by him. But our child is in the custody of the Balaji.
That's right, but I issued notice that they will come and give you the child. You have not filed requisite.
And so far the CWC,
Why have you not filed requisite, you tell me?
so my lord, 5 is concerned, State Council, 7 is the
7 and
Bharat.
8, I am telling you, 7, 8.
8 is the informant.
Notice issued, I have issued
My
notice,
lord.
filed requisite.
Then let's keep it to up next week. Next week, today
Next
itself.
week,
we
not
file.
Body learned counsel for the petitioner undertake to file the requisite during the course of.
In course of the day.
Let him do so. Leave him at next week. Next week.
Right.
File the requisite, right?
File, my.
Go and file it.
Next Monday. Or Tuesday.
Yes, even at least, no. Let it
Notice
be.
is required to be given. Yes, I
Ah.
understand my lord.
Yes.
Notice is given to us. It is our
Sir,
mistake,
sir.
man.
Immediately.
Yeah, our mistake.
44.
Right, please, your lordship. My lord, 44, your lordship, is a very small matter, your lordship. I am challenging the.
Small matter, how many hearing you have taken?
My lord,
Many.
I have filed an IA, your lordship, for the compelling reasons that your lordship may clearly take up this matter. Only your lordship will require 5 minutes. The matter, if your lordship permits, I'll place it. I am challenging the order of discharge, not discharging me. Even if totally prosecution case is admitted, I'll admit total prosecution case.
Yes.
There is no material to connect me to the crime. There is no material to connect the petition.
My lord, Mr. Sarangi starts the new year with a case, my lord, involving an arguable point, my lord, in his favor. If my lordship permits, my lord, there are 46 soft rooms. It's a place known as Paradev Gard.
I may be permitted to place the fact. Only I'll require 5 minutes to show whatever allegations they are making. 13(2), 13(1)(d), 120(b) cannot be made out. I have got a clear judgment of our own Hon'Ble High Court that conspiracy is to be proved by showing at what stage we have conspired, at what stage I have demanded, whether I have got money, whether
Meeting of mind precedes the crime.
making the meeting of the mind before the crime, preceding the crime, meeting of the mind. Nobody has stated I have demanded money. Nobody has stated I am gained illegally. Nobody is saying that I have ever demanded, received.
So, what are the allegations?
My lord, the allegation is that.
Mr. Das, ready? Proceed.
Yes, my lord, it can be disposed.
My lord, there is my lord. Very briefly, the allegation is that informant says 46 soap rooms were required to be distributed under the provision of urban amenities at the Pura scheme. Provision of urban amenities in rural areas. There is a scheme. Under that scheme, soap rooms were constructed. 46 soap rooms were distributed. Lottery were invited. Now, lottery lifted on 7/12/2012. That's a very important date, your lordship. On that date, lottery was to be lifted.
7/12?
7/12/2012. My lord.
Yes.
Now, 76 applicants were there. The informant says, who happens to be a lawyer, the informant says that favoritism has been done. The husband of the sarpanch, other local authorities, their relatives, they were given the soft rooms. This is the allegation. So the informant alleges that there is irregularity. He doesn't say exact what is the irregularity, but this is the irregularity because some selected persons, those who happens to be the relative of those local persons holding posts, they were allotted the soft rooms. Now at this juncture, your lordship, I may respectfully submit, the persons, those who have not been allotted soap rooms, they have not complained. The persons, those who have been allotted soap rooms, they have not complained. The persons, those who are alleged to be the beneficiary of this transaction, they are not accused persons. Now, on this basis, my role is that, your lordship, I was working as an welfare officer at that time in Panchayat, the SC/ST Development Department. Now, this is what done by the Panchayat Raj Department under the scheme. The BDO, who happens to be my authority, he called me that for CORAM, that committee CORAM, 6 persons are required. I, being the junior, working as a clerk to the BDO directed that you remain present there in the committee. So, as per the obedience of the direction of my authority, I went to that committee, that soap room market committee. I went there. I was there. Then on 7/12/2012 itself, in the noon, I was directed by DWO Jagatsinghpur, District Welfare Officer Jagatsinghpur. This is being done at Kujang. I was directed by my officer DWO Jagatsinghpur to come and attend the review meeting there. So I immediately left that place.
I went to DWO office Kujang. These are on record. The Satyapira Sahu, who happens to be the DWO Kujang, his statement was recorded. He said that yes, I was present there in meeting. My presence in the register has been seized by the IO and produced in the supplementary charge sheet. Now, the only allegation against me, Your Lordship, that I was present in that meeting. That is the only allegation.
Who are the other accused persons?
The main accused persons, BDO, Rajkishore Ponda, unfortunately, he is deceased now.
Okay.
He is no more. Other accused persons are Sarpanch and
all the members of that committee.
No, my lord, the Sarpanch and other, yes, Your Lordship,
All the members.
members.
Yes.
So, to sum up the allegation against me, Your Lordship, the only one-line allegation, at best, they could substantiate that I was present in the meeting.
Let us see the charge sheet.
My lord.
Come to the charge sheet.
That is under 13 to 13(1)(d).
Come to the charge sheet again. Yeah. Where is that charge sheet? Charge sheet?
Charge sheet annexure karini. I have got the copy.
Charge sheet is the basis.
My lord.
You file charge sheet then. Without charge sheet, how can I decide whether charge has to be framed or charge has not to
Your
be
Lordship
framed?
has called for a report.
Charge is framed on the basis of the charge sheet. Where is the charge sheet?
Your Lordship has called for a report from the authorities, Vigilance Department. That is there, Your Lordship. My Lord has directed as to exactly.
If Lordship permits, Lord, may bring to Lordship notice the earlier order passed by the earlier bench, on bench, Lord, 14/7/2022.
Yes, Your Lordship.
14/7.
14/7/2022. Lordship kindly peruse that orders. In compliance of that orders, my lords.
Yes.
In compliance to the orders, my lord, a report by flag B of Lordship, my lords, flag B. Flag B has been filed, my lords. In compliance with this order dated 14/7/2022. Flag B, my lords.
Flag B or
Flag B, my lord.
B, Bombay.
Bombay.
Yes.
Lordship got it, my lords?
What have you said there?
Your Lordship can turn to the second page. Lords, the basic thing is that 46, Lords, you can turn to the second paragraph. Basing on
of the case.
Basing on the guidelines of so and so, Lords, video Kujang intimated regarding the change of chairman. In fact, my lord, let me place two lines only. 46 shop rooms, Paradip God, my lords, and my lord, there is a selection committee. In that committee, that collector directed that ADM Kujango, ADM Paradip will be the chairman. Lord, that was intimated to the one of the accused, that is BDO Kujang, my lords. BDO Kujang, my lord, got that intimation that selection committee is to be chaired by the ADM Paradip, my lord. In lieu of that, my lord, he himself formed a committee and under his chairmanship, and included some other persons, my lord, including the petitioner's name, my lord. And Lordship can, what is the complexity, my lord? Lordship can turn to the third paragraph, violating the above guidelines. The guidelines says about the ADM Paradip will be chairman. From the committee under his chairmanship, attended by so and so and so, and and Tapan Kumar Sadagi, he is the my lord's welfare extension officer, petitioner accused before Lordship, my lords, and distributed all the 46. And what is the informative complexity? Lordship, we can skip the second last paragraph. Besides what the committee meeting in the irregular manner, the committee has distributed the shop rooms, shop house to the kith and kin of the committee members. So Amullah Manti, so and so, so and so, and so and so has been allotted room number 14. He is the husband of Sarojini Manti, Panchayat Samiti member of the committee, that one of the member of the committee, my lords. Then two, Sanjay Kumar Behra, so and so, my lords, has been allotted to so and so. So Kamala Behra, my lords, so and so, my lords, has been allotted room. So the husband and mother-in-law, husband and mother of the Sasmita Behra and Sarpanch Paradip God, lords. My lord, it's a pure coincidence, my lord, subject to Lordship appreciation.
But any relative of this gentleman?
No.
Oh my God.
That's a catch. Well, that's a catch. Lordship rightly clinching the issue, my lord. My lord, he has not inducted any.
Not a beneficiary.
No, my lord.
It's a coincidentally his name was inducted by this.
Then what is the role attributed to him?
Exactly. Lordship, I record my objection.
The Committee is constituted by BDO. He is the clerk.
No, in fact, he violated the guidelines, my lord, fixed by the collector.
The BDO has done it.
The same accused, my lords. And he himself became the chairperson in lieu of the ADM, my lords. That is specific direction.
BDO is Rajkishore Panda.
But he is no more, my lords. But he wanted to put some people in that committees, my lords, and he put people. But the beneficiaries, my lord, who in short is the Keith and Kale, my lords. My lord, he doesn't belong to that category, my lords.
And there is no allegation of any money.
This is the report. My lord. This is the report. No pecuniary loss, my lord. No pecuniary loss.
No pecuniary loss. I have never demanded, never obtained, no allegation. Nobody is making a single statement. I have gone through your lordship the entire 160.
This report.
Not a single person saying that I have ever demanded or favored someone.
But on the basis of this reports, my lords, which was on the basis of the materials on records, my lords. My lord, in fact, this revision is directed against an order revision discharge application, my lords. My lord, because in the charge sheet that that culminated with an rejection orders, my lords. But so far complicity is concerned, my lord, other members of that committee, my lord, they try to induct their own kith and kins, my lords. Not this guy, my lord. This not this petition. And my strong objection was recorded.
Before vacation, when the matter was there, my learned senior said there is a ray of hope. Your lordship said, for whom the ray of hope is? For you. Your lordship may. Because
present petition is seeking the questioning of the what are you seeking here?
Discharge. I am praying for discharge.
That is at page 41, annexure 5.
Petition is agreed by the order dated 5/4/2022 passed by the Special Judge Vigilance Cuttack, so LTR case number 30 of 2017, whereby his application for discharge has been turned down. The petitioner is one of the accused in FIR number 4. After investigation, give me the charge sheet. Give me the charge sheet. Investigation, the charge sheet will be filed in investigation potential. The allegation against the petitioner in the charge sheet reveals agent. That should be the matter was the
order date 14/7/2022 to 22. 14/7/2022.
Earlier you approached this court for earlier. You had earlier approached? No. Charge sheet. And the report is also a production of your charge sheet only.
Correct, not in total. This is correct. In fact, I have got lots in complete reflection. And in fact, they cannot go beyond the charge sheet lines. They can make out a new cases.
The petitioner moved an application under section 239 CRPC seeking the discharge from the entire case. The said application was turned down by the interim order dated 5/4/2022. Dismissal and for the उसके बाद by order dated when the matter was taken up by this court on 14/7/2022, the following order was passed. Para 3, that order. Para 3 of it. Pursuant to the aforementioned order, the
report dated
report has been
dated 1/8/2020.
Status report dated 1/8/2024 has been filed inter alia stating agenda.
That the collector had letter dated 26/11/2002 to 12 directed the video.
Paragraph I want to read.
And that's the second page, not the second paragraph. Basing on the guidelines of the report, letter number so and so.
Based on the guideline rule, continue.
Regarding the change of chairman of the selection committee, my lords. that ADM Paradip will be the chairman of the committee. In violation of that thing, Lords,
Existing guideline for the distribution of the software. I'm just preparing a rough draft so that it will be clear. Otherwise, all the work is getting accumulated. Accumulated. So therefore, Mr. Mitchell and for the petitioner submit that except even if the entire case of the prosecution is accepted at its face value, no pleas will be made out against him. He further submits that the charge sheet, the result of the charge sheet, as well as the status report placed before the court, reveals that the petitioner has only participated in the meeting
because his name was inducted.
Convened by his boss, that is the video. None of the neither any benefits is derived from the allotment process by the petitioner, nor any kit and kill were allotted any shop. Any shop. There is no peculiarity loss for the status.
Nor misappropriation.
Or any there is any allegation of misappropriation. Mr. Mishra further submits that neither the beneficiary, neither the agreed participant, neither the beneficiary of the scheme, nor any person who is agreed by not getting the shop have come forward to complain. Rather, it is an individual, nothing to do with the entire transaction. Being in a booklet, practicing a booklet, and filing the complaint on the basis of which the entire criminal law is set to be motion against him. Mr. Das and the vigilance, on the contrary, has vehemently opposed the praise made by the petitioner on the ground that the factual disputes which is factual dispute writ large in the present case need to be thrashed out in the trial alone. At this stage, this court, while deciding as to whether the charge is against the petitioner or not, need not venture into the factual dispute by appreciating the statement for the witnesses recorded in the 161 CRPC. I have to carefully go through the entire record and entire record and to consider the submission made by the respective agencies of the bar. I am of the concern to review that it is evident in the record that even if the allegation of the prosecution is taken at face value, no charge as such is made out against, no offense as such is made out against the present petitioner. Petitioner is one of the members of the committee constituted by the video. No benefit is derived by the petitioner from the entire process. Has been imputed against him. Against the perusal of the charge sheet further reveals that it is the all our serpents relative.
Sarpanch, Keith and Kings.
Reveals that the Keith and King of the serpent the soft, the soft. In the absence of any specific allegation against the petitioner regarding any financial misappropriation or benefit being derived from the entire transaction, a mere participation of the petitioner in the meeting convened by the video will not bring necessary against.
Or induction, somebody named by the main accused, Mr. Podda.
The accept and accept the allegation that he was present in the meeting.
Yes, sir.
No other
My lord.
attributed to.
Lords, may I add one word, my lord. Lords, you said that ex-sarpanch and stroke ex-panchayat samiti
member.
Benefit.
oblique.
Benefited to सरपंच and पंचायत समिति.
Again, এটা কোন দিকে that is regarding our own honorable High Court judge. এটা ঠিক আগে রাখছেন।
সেটাই মতে কপি
আগে prior meeting of mind at what stage in what manner they have mu just খালি টিক মার্ক কর দিয়েছি। মু টিক মার্ক কর দিয়েছি at what stage in what manner they
What is this?
paragraph 19 that is exactly a lordship discharge petition our own honorable High Court said when where in what manner such agreement and understanding has been done.
Mr. Mishra
My lord.
to buttress his argument.
Inferred as
relied upon
conspiracy.
Conspiracy.
It has to be inferred, my lords.
That is also there. That is discussed.
Which paragraph? Whenever.
Paragraph, my lord, that is, I have to made a tick mark.
Whenever,
Whenever, Last line says, furthermore indicating as to when, where, and in what manner such agreement and understanding were arrived at.
If a lordship turn to para 6, my lord.
That is to be inferred also discussed.
If a lordship.
He buttressed his argument. He also relied upon the judgment and by emphasizing the following paragraph and he submits that for the purpose of bringing home the charge under section 120B.
Yes, sir.
Specific allegation need to be made in the FIR and the charge sheet. Preceding the crime, there is no evidence brought on record by the prosecution regarding the meeting of mind preceding the crime. No charge under 120B is also made out. Yes.
But that same judgment, lordship can advance to para 6 more. Same judgment.
Para 6.
Not to be quoted, only can lordship can.
Para 6, yes.
Para 6, my lord, my summons is recorded, my lord. No, para 6, my lord. The so-far concept of conspiracy. My lord,
if you don't want to give relief, many paragraphs. If you want to give relief, one paragraph is enough.
to be inferred, my lord. That cannot be direct evidence.
Find out paragraph where we can give relief. Forget about. Then many paragraphs are there, not to give benefit. Then you see, in these kind of cases, even if we face trial, what will happen? Nothing.
It ended in a fiasco.
Yes.
Ended in a fiasco.
I led all the other things. I led. Yes.
Obliged.
Judgment reserved. Yes.
45.
Today's proceeding, just argument heard, judgment reserved. Draft bring on final yes. Yes. 45.
Item number 45, my lord. Served a copy of the order dated, my lord, 23/12/2024 yesterday, my lord. From where, my lord, I came to know that, my lord, the matter was taken up on 23/12. Hard copy. Today, lord, can you see the order, my lord? I was supposed to reply, my lord. Today, I will reply, my lord. But prior to that, my lord, I am showing the things, my lord. Lord, can you see the order dated 19/12/2024, my lord? 19/12/2024. My lord senior has already completed his argument, my lord. And my lord, on 19/12/2024, my lord, I made a mention with your lordship, my lord, there is a bereavement in my family, my lord. And that is why, my lord, your lordship has adjourned this matter, my lord. Thereafter, my lord, a miscase was filed. IA number 3414 of 2024, my lord, the copy of which, my lord, has not been served upon me.
What is that miscase?
Miscase, my lord, for extension of the interim order, my lord. That is why, my lord, the matter was listed on 23/12/2024, my lord. And the, my lord, order dated 19/12/2024, my lord, has not brought to your lordship's notice, my lord. That matter has already been adjourned to 13/1/2024.
It was
25. And my lord, the order was passed 23, my lord. Then release this matter on 3/1/2024, my lord. My lord senior has completed his argument, my lord. My lord, today I will argue.
Come to the point.
My lord, since because, my lord, your lordship has taken a wrong view about me, my lord.
No.
Before
that is why, my lord, I explained, my lord. What is my position?
any misgivings, my lord, I am saying sorry. On behalf of everybody here.
My lord, he is my senior, my lord.
Or no, neither he takes it seriously, nor he or not me. Forget about it.
So
come to the point.
That is why, my lord, I explained myself, my lord. Why on the last occasion, my lord, due to non-service of the IA, my lord, and the IA was posted
That
for,
was the mistake. That was the
my lord, the IA was posted for, my lord, extension of the interim order, my lord. I took it is very lightly, my lord. The IA was filed for extension of the interim order. That is why, my lord, I was not present on that day on 23rd.
Are you ready now today?
My lord, I was forced to ready yesterday night, my lord, because when this registry, my lord,
Why do you
started-
waste your labor yesterday? Labor, you now argue.
Yesterday, my lord, a copy of this order dated, my lord, dated 23/12/2024 was sought by the registry upon me, my lord. And from there, my lord, I found that, my lord, it was a mistake on my pad. I could not present on 23/12/2024. That is why, my lord, your lordship has protested it and give me a last chance, my lord, to argue this matter. That is why, my lord, to sum up the entire.
Have I shared that last? Huh?
Yes, my lord. Make clear no further adjournment shall be granted in this case.
Yeah.
That is why, my lord, I am supposed to, my lord.
Shall I keep it at 3 o'clock so that you can?
No, my lord, the whole thing, my lord, I have gone through the entire application, my lord.
Yes.
Here, my lord, I am making my argument, my lord. Here, my lord, the prayer of my learned senior is to, my lord, quash the order taking cognizance, which was taken against the, my lord, which was taken for the offences under section 376(2) and of IPC.
Yes.
506/342 read with section 3 of the SC/ST Act, my lord. FIR was lodged at the belated stage, my lord. That was the main contention of my learned senior, my lord. And prior to that, my lord, a committee was formed. Before the committee, my lord, sexual harassment committee, my lord. Before the committee, my lord, the present.
Have you filed a written note?
No, my lord, I have not. My lord, I am making my argument today, my lord.
Yes,
Give you all
file.
the chance. Yeah. So, my lord, my learned senior has placed the past statement made by the Satyamanama Behera, the present informant, my lord. You will kindly come to page 40, my lord. That was the contention of my learned senior that he changed his version thereafter, my lord. A further statement was recorded, which was at annexure 10 of the present CRLM says 47, my lord. But first statement, my lord, which is at page 40, my lord. I want to draw your lordship attention that, my lord. She has not changed her version, my lord. Rather, in her first statement, my lord, if your lordship will see, my lord, page 44, that is the statement, it has been annexed here, my lord. Your lordship, my lord, I am drawing your lordship's kind attention to page 44, my lord.
Page
44, my lord. The line starts with गत 14/9/2015 दिन मु बीबीएसआर जीआरएस थानारू मो क्वार्टर को गली मु जीवार किछि समय परे आईआईसी मो क्वार्टर को गले दिन प्राय 4टा समय होई थाए से मते कोन खाया को अछि दे बोली कहले मु तांकू मो पई ग्लूकोज पानी करिके आनिली से मते टिके पीबा परे किछि मिठा होइनी माउ टिके चीनी आन कहि कि मु जागी आसीबा परे से ग्लास रे किछि निशा जिंस मिसे देथिले मु निजा न जानी ता पी देबर मोर मुंडो बुले देला मु बेहोश होई गेली मते सब झापसा झापसा देखा जाउ
letter written by the petitioner to the respondent is outdoor seized. Also seen the form part of the case. It's a long time, but the state seeks to place on record those documents. That in doing so we can release the matter on 9th for further reason.
interim order.
Interim order.
Not.
Yes.
46.
46 will also, last thing also directed to enough to ask them what the status of the PS case number 185 per option, which was lost by the present petitioner. 46 your option.
46 pass out, pass over 2 o'clock.
Yes.
Pass I think 142 was passed over. I was sorry, my lord.
Huh?
Modification.
Which one?
42.
I'll 42.
Huh. Since I have a election matter at 2, I'm bothering your
Let
lord.
us take
Beg
it.
pardon.
Okay. Yes. 42. One. Yes.
In fact,
What is this modification?
your lordship taken note of the fact that he was produced before the court on ambulance. Your lordship stayed the NBW issued on 410 and granted liberty to move the interim bail. But in fact, the interim bail was dropped and NBW has been issued. My instinct could not, I could not apprise your lordship
that it is only after interim bail is refused, the NBW has
Which
been.
part you want the modification?
My lord, I only say that the paragraph 5, Lordship, for a moment,
Regarding here to the aforementioned, the execution of NBW issued by so and so,
which is pending before it,
petitioner
or
is state till so and so, directed to decide the application for interim bail. Yes. What do you want now?
now it's not pending, my lord. It's not pending.
You move a fresh application? Not pending.
Yes,
Move a
yes,
fresh
yes.
application.
Fresh application, that liberty, unless that is there, my lord, or any fresh application is moved. That,
Mr. Das, Lieutenant Counsel for the IA,
yes, Lord.
Counsel for the petitioner submits that and the last part of the order dated 13/12/2024, some error has cropped in. In fact, the interim bail application moved by the petitioner had already been disposed of. Therefore, he needs to move a fresh application. In that light of the matter, he seeks a modification of the order dated 13/12/2024. The para 5 of the said order may be replaced by the following paragraph. Regarding the issue, para is state till 31/12/2024 the same version. After the close, the Learned Trial Court is directed to liberty is granted to the petitioner to move fresh application for interim bail. If such application is moved, the same shall be considered on its own.
And the stay was only up to 31st. Stay to move that for
Review up to the aforementioned modification, the interim the execution of the NBW issued by the Additional Sessions Judge Umar Court, LTR case number 32 of 2022, dated 4/10/2024, shall be stayed till 20th of January 2020.
It may so happen there may not be any need. They may not survive. What information I have taken today. Again, ICU and daily dialysis.
Then you move immediately. I stayed for till 25th January. 25th January. You today or tomorrow you move application so that
Tomorrow.
it will still come out.
In course of the day, if it is.
And there we the Learned Trial Court is also directed to dispose of the interim application forthwith. At least he should come out. Yes.
Great.
Yes.
Item 59.
59, somebody mentioned.
It takes a short date, my lord. He is in deathbed, my lord. It's appellant.
Okay.
After retirement.
Next week I have added in the weekly. And
Any date maybe.
yes. Monday. Next week is Monday. Hey. Yes. You mention it so the morning. We will be there.
Okay.
Yes.
Item 80.
Yes, sir.
It will be entered in one proceeding. On the ground that the matter was separate between the parties. And the victim is going to marry another person. 376 and POCSO in.
What to do? Investigation is complete.
Complete.
Charge sheet is filed.
Your lordship go to the victim statement, innocent, recorded by the police, page 23.
23.
Well.
Yes.
No such and such, and chamber camera.
Age, what is the age of the girl?
That time, my lord, he is 16, more than 16.
No, that is 15 years, 5 months.
Well, you tell me how to go about it now because of that judgment.
That judgment, my lord, your lordship is hard. And where there is a, my lord, public in nature, my lord. So suppose student and teacher-student relationship, or possibly very, but it is a consensual relationship, the teenage relationship.
Where is the affidavit of informant?
My lord, your lordship got a first time.
I issue notice of informant. Issue notice to informant. I just issue. Some affidavits, some, I understand the problem is because of the judgment, otherwise you are covered. I just issue notice. Okay. I move application before file court. What is the case? The charge?
No, charge is not my petition, not arrest. I approached this on report, but rejected. No questions.
No. Once rejected, I can't supersede that order, no? Rejected means that I can't.
Absconder, he has been declared abscond.
NBW issued.
NBW issue.
Show me when NBW.
Yes. In charge sheet, the lordship page 21.
No, you have not said application, regular bail application is rejected. Sorry, anticipatory.
I have given.
Where is that order? Where is that?
What I mentioned by ABL number 12575 of 2021, disposed upon 26/11/2020.
That's the problem. It is rejected. If I pass an order, then I'm virtually nullifying that order. That's the problem.
The stage charge sheet was not submitted, and
that time you had a better case. I issue notice.
Fix a date.
Date you fix after 1 week fix. Informant, take notice to the informant. If she comes, then we'll see.
Yes.
Find out some way out. I'm ready to do it. But the that.
Last time you had the matter. So 164 more do that. 164 statement खाली आसिले
Good.
You are also in the 164 statement. She has deposed that he has committed kidnapped and
161
in charge sheet that has been reflected.
In 161 से कोई चीज जो मुझे जायची.
No, let us not go to the merit of the case. How to get out of the just see the judgment and. Yeah.
36.
Yes. Yes.
After working for since 1999 to 2022, the petitioner was disengaged from the service. And it is a review application. And
yes,
the order matter as by this one 11/10/2022, there is a error apparent on the record that people not speak the extended permission only the single judge has stated that I have worked for only 44 days.
Yes.
Of that within my lord.
Yes, I am. Yes, sir. What do you say?
I am appearing on behalf of the staff selection function.
Who is appearing for state?
My lord, I am.
What do you think?
My lord, actually,
There is an apparent error.
contesting party is my lord staff selection commission because
No,
he has,
they are the agency for recruitment. You are the.
he is the employee of.
He is actually the employee of this.
What do you say?
So, with respect to this factual aspect, madam, whether the observation of Honorable Single Judge is actually correct, that beyond that particular period, whether he was in service or not, we have filed one objection in this reply to that review petition, madam, in this case on 5/12/2024, wherein we have admitted. We have admitted in para number 2 that he had continued in service beyond 30th 4/1999 till 30th September 2022 on ad hoc basis, 44 days spell basis, by giving 1 day break in between 2 spells in this commission.
If that part of the order is corrected, what will be the consequence?
It's a case related to regularization of the service. So, but regularization of service, that is to be taken independently. But to that extent, that whether the observation of the Honorable Single Judge is correct in that particular input order.
That portion, even if you correct the, what will be the relief?
In that case, observe that since I have worked for only 44 days and no
regulation can be done.
No regulation.
So what I'll do is I'll allow the review petition and set the writ petition to be
to the original bench.
That's the best way. Okay.
Assignment nahi, take a review.
Once a review.
Right. The matter was the review petition was taken up for hearing on 12/11/2024, and the following order was passed by this court. In pursuance to the aforementioned order, the contesting respondent has filed a reply dated. When have you filed the reply? Dated
On 5/12/2024.
5th December 2024, inter alia contending as under para 2 and 3. Para 2 and 3 of the affidavit. Affidavit. It is accordingly it is admitted by the contesting respondent that the 11 single judges for this court in para so and so, which paragraph? In para, where is it? Para 2, na? Para 2 for the impugned judgment dated 11/10/2022 has recorded a fact which is apparently contrary to the record. In view of the same, the apparent error cropping on the record is writ large, hence the same needs to be corrected. In view of the same, the review petition is allowed, and the writ petition is set for disposal, before the assigned judge, subject to the approval. FRS, writ petition is set for hearing. FRS on its merit. Yes. Review allowed.
46.
Last one also directed to obtain instruction regarding the charter of the case filed by my learned friend, the PS case number 185 and 291, Your Lordship. And as for my impression consent, though the case has been dropped, that is by saying mistake of fact, Your Lordship. Final report is filed, Your Lordship, false.
Yes, madam.
Annexure 4.
No, you want the quashing of the FIR. They say that the investigation is complete.
So far, the FIR was by my learned friend against the other accused persons. That case has been mistake of fact has been subsequently filed. But the FIR which was lodged by the other person against my friend,
what happened there?
That case is subsequently filed.
That is filed. Yes.
And one more submission also, what happened in this case, also the main root of the case is that the late father of my learned friend has purchased a piece of land in the Barampur town and having a constructed building. And due to matrimonial dispute by my learned friend's father and his wife,
There is the wife and now my girlfriend is staying in Qatar and her father is staying in Berhampur. And while he was staying in Berhampur, neither of the present petition or her mother take care of that her father. At that time, while he was staying in Berhampur, the brother and sisters of the father of my girlfriend is taking care of at that point of time. Now her father is passed away due to COVID-19, Your Lordship. And during that time period, Your Lordship, the late father of the present petitioner has willed the said scheduled land and building to his brother and sister.
That was self-acquired property.
Yes, Your Lordship. Now that main crux of the matter is that, Your Lordship. After this, now my friend is claiming that I am the owner of that property. But now that
Yes, madam.
house is there.
It's self-acquired property. Your father has
Already willed,
in favor of the sons and all.
He had a separate public on the person of his members.
ROR doesn't extinguish right title and interest of property, but there is a will probate now.
But this case has nothing to do with that.
Yes,
Just tell me, why should it be quashed?
This is has no rights on dealing with the civil case. Secondly, ROR already is registered.
ROR doesn't.
ROR will not decide the title.
ROR is registered, mutation already over, and I have to separate copy also.
But how does it make difference in so far the criminal case is concerned? You satisfy me on the facts. The FIR which you registered ended up in a final form.
When first tenants were residing in the house, police took the matter and they have vacated without my knowledge. And they said that, okay, madam, you go, your already house is better. When I reached the house, after half an hour or 40 minutes, 4 to 5 persons, they came and house trespass inside my house.
You filed a case which was investigated and ended up with final form. You have a remedy. You file a protest petition against that.
I want to show my lordship. This is the page number 97, my lordship.
Come to this case. Why it should be quashed? You tell me. What are the allegations?
Page 19 is the ODI Lordship. Married Lordship. Married, page 19 is the relevant page, Lordship.
Yes.
Sumitra Behera, ବୟସ ସୋ on ଆଜି 23/21 ଆପଣଙ୍କୁ ଲିଖିତ ଭାବରେ ଜଣାଉଛି କି ଯେ ମୁଁ ଏବଂ ମୋର ସ୍ୱାମୀ ଏବଂ ଅବିବାହିତା ନଣନ୍ଦ ଘରେ ରହୁଥିଲୁ ସମୟ ପ୍ରାୟ 7:13 ହେବ ମୋର ଝିଆରୀ ରେଶମା ବେହେରା ପ୍ରେଜେଣ୍ଟ
Serve the notice through IO.
Yes,
They might have called the police my lordship. When in the FIR, my lordship, page number 39. Kindly see page number 39, my lordship.
Which FIR you are reading? Your FIR. Your FIR. Your FIR has already been investigated and final form is filed. I need not go into all these things. Yes. Yes. Yes.
39, my lordship, point number 12, my lordship. I'm just reading the first paragraph on the last.
Yes, reading.
Then she tried to open, then she tried a lot to open the door and finally able to open the door and rushed outside from the house. Thereafter, she was rescued from the alley spot by the help of police and returned back to her Cuttack house. My lordship, if I have made a trouble, they might have called the police. I called police.
Madam, on logically, I can't go because you filed a FIR which has been investigated, final form is filed. You have a remedy of filing protest petition. You file it. Insofar as the FIR against you is concerned, there are allegations against you. Investigation has been completed and charge sheet has been filed. You satisfy me. You say that it is a dispute land dispute between your brother and you. That cannot be sorted out in this proceeding. Then I can't sort out those things.
Let notice issue, let OP will also appear resolution,
Sir.
because family dispute you will also admitted.
You, sir, once
No, I will.
anybody appeared,
And
who is not opposite 4?
yes.
2, 3, 4. Sir, press notice on 2, 3, 4, huh? Through IO of the case.
No, you also only private OP4 is the contesting. Sumitra Behra is with the
Who is Savitri Badi?
official capacity individually acted as a party. IAC Solicitor Police को party करछन.
You are a service करो 4.
Only notice OP4.
No, only 4.
Yes, yes.
Entry mode to continue. Okay, next.
47.
Yes, sir.
The case was registered in 2021, September.
Yes.
This honorable court has already had an order for giving charge sheet. It has not been filed. More than 1350 days have been passed. In the meantime, the petitioner has met.
You have not filed the charge sheet, copy of charge sheet.
We call for the.
January 23, the order was passed.
Yes, yes.
Why have you not filed?
We have called for the CD, but in the CD, the charge sheet was not there.
Right on.
Here.
Why the order dated 5/1/2025, specific direction was issued to State Council to file a charge sheet. However,
notice to appear.
However, charge sheet, copy of the charge sheet has not been placed on record. Mr. Vishwal seeks a last and final opportunity to place on record the copy of charge sheet. Please see matter on 7:30.
Charge sheet also, a suicidal note is there.
Whatever you want to file, file. What do you want to show, sir?
They have served the notice. SDGM court has not served the notice to appear, but I am enjoying petition from this court.
You might have got the charge sheet copy.
No.
Basic trial court might have given you. It is now fixed for charge copy of this thing for framing of charges.
Then I will apply and get it.
Counsel for the petitioner also submits that the client might have received the copy of charge sheet, and that he will also make sure that the charge sheet copy is filed. Yes, next. 3 weeks for next.
48.
Final protection.
I give it. Yes. 48. Yes, 48.
My lord.
On request, adjournment. Yes.
49.
Item 49, also kindly dispose this matter with liberty. The petitioner to renew his prayer at the time of framing of charges.
Land counsel for the petitioner seeks to withdraw the present petition with reserving the
kindly
right to
dispose this.
litigate the issue before the court below and that will be disposed of with the liberty of the
Your Lordship, I am appearing for the informant. The last occasion, the order that was passed by this honorable court, the name of the previous counsel has been mentioned. So my name may kindly be mentioned.
Lordship, in item 49, Lordship, the name, the brief has been transferred. So the names of opposite party number 2.
49, this is 49?
This is 49.
Yes. Okay, next. Entry model will continue, yes.
Your Lordship is disposing of item 49.
Dispose of.
Grateful.
Item 50.
What happened? Mediation failed.
Report has, I think that has.
Mediation failed. Who is appearing for the other side? So mediation, the matter was referred to mediation. Mediation report dated so and so indicate that the mediation process remain unsuccessful. Release the matter for final disposal, interim order to continue. Now may be for response. Yes.
May it please your lordship.
Yes.
Lordship, kindly see on our deadlines. 20th February 2024, my lords. Case arising out of a village dispute. 4 cases initiated. These 3 cases are the complaint cases. One clear case, already was your lordship was pleased to pass to one clear case of blessing upon the compromise. On that day, as per lordship's direction, all the villagers appeared before the IIC Chandpur.
Yes.
Along with the joint affidavit.
Yes.
I'll take instruction whether that to whether they have appeared and filed their respective affidavit.
Directed to verify the fact and furnish a fine instruction to Maharaja. See the order dated 48/2/2024 has not been complied by NA. In pursuance to the order dated 48/2/2024, no instruction has been received by the State Council. These particular treatments. You speak to the IIT. Issue notice to opposite party number 2 to the
Notice जाइए आगे यहाँ पे।
IIC through IIS.
थोड़े जाइए से आसिला नहीं।
IIS.
Through IS.
Entry order continue.
54.
Yes.
I may please, ma'am. Here, I have challenged the order of the entire criminal proceeding initiated under the Negotiable Instruments Act. The probe is on the ground that here the London magistrate, what he has done, that he has condoned the delay in sending the statutory demand, legal demand notice, my lord. But that is not the law. My lord, may kindly say page 10. The order of provision.
Notice was issued?
Yes, I have already appeared in this matter also.
Yes. Page 10, huh?
My lord. Page 10. Had submissions from the side of the complainant.
Page 10.
Page 10.
That's 9, yes.
Had submissions from the side of the complainant and perused the case record. There is a delay of 7 days in issuance of demand notice, not in filing the case, my lord. On consideration of the facts and circumstances, the complainant has been able to put forth the grounds that he was reasonably prevented by sufficient cause for issuance of demand notice in time for situation beyond his control. So that is not the...
Definitely, initially the knowledge that the state was duly bound, the demand notice was actually issued to the petition accused person. And that notice is due to the inherently the bank.
You just simply tell me whether statute provides condonation of delay for issuance of notice under 138. That the earlier thinking was
Para checking your last two lines.
there is a typo.
State Bank of India
And check number, everything is
Everything
same.
okay,
So there is a typo then.
Yes, sir.
There is a simple typo.
Yes, sir.
And where is the second notice?
That was also 22 for that is page 45, page 20 or
When I replied at given.
page 20 or
This is the reply he has given.
Yes, sir.
Reply I have given at page
That is what I
7.
said.
Only after getting my reply, yes.
Regular transaction is there also after 423 after bringing the notice at that fact. Immediately the present party workshop corrected and issued the second notice also. And then
Read the second notice first paragraph.
An invalid notice cannot form the basis of filing a complaint, my lord.
No, there is a typo.
Oh,
The typo is corrected in the second notice. It is not the second notice.
That is also
It's a correction. Show me any judgment.
That, my lord.
Show me any judgment. A typo in the first notice cannot be corrected. Only the name of the bank is wrong. He corrected it.
True.
Then it should be treated. So that the limitation should reckon on the first day, not the second day.
That is an invalid notice. Then I have then I have no scope to reply to the notice, the second notice, my lord.
That is a very clear one.
That's yeah, we have taken away the check. That was take a check, takes up in stolen. These are the points of fact. Other two. Business relationship was there. That is the point.
Passed by Legend STJM Barampur in ICC case number 213 of 2013, whereby cognizance of offence punishable under section 138A9 of has been taken against the petitioners. The petitioner is agreed by the said order. Hence this petition. Legal counsel for the petitioner submits that the legal counsel of by taking me to the impugn order at para so heard para heard the submission from both side complaint. See paragraph 2 last impugn order submits that the court below, while condoning the delay of 7 days in issuance of demand notice, committed a serious procedural error and hence the cognizance order itself is very long. Very long. I have perused the record and record. It appears from the record that initially on 20th, 28 the petitioner, the opposite party issued the demand notice.
Pardon, my lord. My lord, may kindly give one chance more. Upon the order to have a you I'll find out where the decision, where the name of the bank is different. Upon pattern I will see the
name of the person, name of bank.
Name of the bank, yes.
Which is corrected. So,
say item what it is on the देखे अपन पार्ट को रख दूं तो कुछ असुविधा नहीं
ମୁଁ ଲେଖେଇ ଦଉଛି ଡ୍ରାଫ୍ଟ ଆଉଟ୍ ବନେଇ ରଖିବି ପ୍ରିଣ୍ଟ ଆଉଟ୍ କରି ରଖିବି ଠିକ ଅଛି କଣ ଲେଖିବେ if you can give some judgment then I'll record that initially on of opposite complaint issued demand notice first demand notice to under section 138 NI Act NI Act there was a typographical error committed by the opposite party in the counsel for the opposite party in the demand notice by instead of which bank instead of
State Bank of India has been State Bank of Utkal Takis Road Asika branch
which is the right bank
Andhra Bank
instead of Andhra Bank
Utkal Takis Road
Aska Road Aska branch inadvertently State Bank of India is mentioned in the notice. The petitioner who is accused on 6/5/2023 replied to the statutory notice dated 28/2024 entry earlier pointing that he doesn't have any account in the State Bank of India. state committee. Realizing the mistake committed by the complainant, the counsel for the complaint, by way of a foreign judgment, issued another notice dated 4/5/2023, thereby correcting the name of the bank. Then the counsel for the petitioner submits that the limitation is liable to be reckoned from 4/5/2023. Even otherwise, the second notice issued by the complainant is barred under the Act. The trial court has indeed calculated the limitation period from 4/5/2023 and arrived at a conclusion that there will be delay for 7 days, which has been condoned by the trial court while in the impugn order while taking cognizance of the offense. Learned counsel for the I am of the considered review that the first notice is being corrected in the second notice. Therefore, the limitation is liable to be reckoned from the first date, that is on first date of notice, that is 20th April 2020. If the limitation is calculated from the said date, the statutory notice has been issued by the complainant well within the limitation prescribed under law. I'll type print out and leave the matter for further hearing on next week. 9th. I'm just pleasing. Since I have dictated the order, a rough draft I am keeping it.
That's it. I would point that there will be
all the point you argue. I'll take it. All the point I argue. I am not passing the order
again.
Today I am only simply adjourning the matter
again
and keeping it on 9th
again.
Since I have already dictated rough draft, I am keeping it. Okay. 9.
Kindly pardon me for the interruption, my lord. Item 49. There was an interim order, your lordship may kindly reflect.
Interim order is there, it will continue. Yes.
It will be vacated because the case was disposed of today. So the interim order may stand vacated.
Do we need to tell that? If the main matter goes, along with that interim order also goes.
55.
Or he has taken the interim order in the back packet or what? Yes.
55. In this case, your lordship was pleased to send the matter for mediation, and the mediation was successful.
Very good.
As per para 4 of the mediation, my lord, both the parties are agreed that the petitioner has to take step for release of the amount of rupees 18 lakhs, which has been deposited by the petitioner before the honorable court below, as per direction passed by this honorable court in ABLFL.
So what do you want now?
Now
Again, I'll form part of this mediation report as part of the order and dispose it up. Comply.
Yes, lordship.
Lordship, I am appearing on behalf of the informant, my lord.
Yes.
Lordship, what happens that the amount was deposited by persons to the order of this honorable court in the name of the petitioner, who is an accused of that case. So let the amount be first released in favor of the informant, that is in favor of me at first, and thereafter let the matter be disposed of thereafter. Otherwise, I will be in trouble because the amount has been deposited in the name of the present petitioner. So the learned court below will hesitate to release the amount in my favor, my lord.
Wrong step.
No. Para 2 says it is agreed between both the parties that out of the total amount of 19 lakhs 70,000, 18 lakhs so and so will be received by the informant from the trial court, which was deposited by the petitioner.
Yes.
It has to go to him.
No, but as because the amount has been deposited by the petitioner, so and in the name of her also, so the lower court definitely will hesitate. So let the matter be.
The informant should have, my lord, approved, because, my lord, the amount deposited in the name of the court, my lord. In the name of.
Whatever pursuant to the settlement, you move appropriate application to trial court.
No,
And
Lordship,
put it next week.
Yes,
No,
Lordship.
I
Let the
may
matter
agree
be
with
put
you on
before
all,
after
my
2 weeks, my
lordship.
lord.
But he is stating that, he said that this is my lord, I have to take step to release the amount in favor of the
No.
informant.
Why don't you move the application
Yes, your lordship. I have no.
before
objection.
trial court?
Yes.
In the mediation, you have assured. Lordship, in the mediation, they have assured. Sorry, my lord, but they are in the mediation, they have
As per
assured.
their
That is the
statement, their
reason.
concern, the petitioner agreed to take step. That is why I filed this.
The problem is the parties are interested to settle, and
Yes.
you people are fighting on technicality.
Yes,
I-
Lordship.
You want to defeat
My lord, the
mediation report.
I have no objection then.
Parties have agreed,
The
and
pe-
you people, both of you
Yes,
will
yes.
start.
The petitioner.
No, Lordship, let the matter be put to end. Lordship, just keep the matter after 2 weeks, and in the meantime, I will file an application before the court below, my lord.
If the parties have agreed for some certain thing, why don't you move application and finish it up?
I have no objection.
Lordship, what happened? Lordship,
You move
what
application.
happened?
No. Friday.
I will.
Friday. You do whatever you want to do. I'll go by the mediation report. I will not go by your submission. Yes. Friday. Do whatever you want. Yes. The parties have settled the dispute. You people are unnecessarily creating problems.
No, I don't have any issue, Lordship, because only.
If you don't have an issue, why don't you move application?
Yes.
Because Lordship, I am very unfortunately, I am submitting.
You move the application simply saying that parties have settled the dispute. In pursuance to that, I am moving this application. As simple as
My
that.
learned brother, Lordship, my learned senior brother was present. Right now, just he has changed his version. That is the very unfortunate part, Lordship. I don't have any other issue, even if I will move the application. But let him admit that what he have assured before the mediation center, my lord. I will move application definitely. But
Why are you making ego issue? Either you move application or he move application. Parties have settled the dispute. You people are unnecessarily creating problems. It is always not necessary that for everything you have to oppose. I send it for mediation so that dispute is resolved. Dispute is resolved because of you people's ego issue. Again, the parties will then move application.
Sorry, my lord, no ego is there, Lordship. Only technicalities. As because the amount was deposited in the name of the petitioner, that is the issue, Lordship.
Move the application, finish it up. Yes.
Yes, ma'am.
Yes.
56, I am for the petitioner, my lord. Your lordship may kindly see the last order of 11th of September. There was a specific observation that both the parties should sit and go for an amicable settlement. In fact, I had given a proposal to Mr. Rath, who is appearing for the opposite party, and he was to take instructions on that, my lord.
There is a chance.
Lord, it's like this. 9 crores of check bounced. She agreed that she will pay it. Both of them agreed that it will be paid. They handed over the check, now the check is bounced. So we are after them since 9th of 2024. Today also what we are saying is they will pay in 4 installments. That is what I am told. If Mr.
I had suggested that every quarter they will be paying 1 crore. So total there is a 9 crore check amount. We are not going into the merits of the case whether we have a liability or no liability.
But see, every quarter means every 4 months.
You will take how many years then?
That is what I am saying. What is this?
It's about 2 years.
Let the trial continue, my lord. They are challenging the shaman. I don't agree to this proposal. Let the trial go on, my lord. Because 143.3 says trial will be completed within 6 months. Today they have already taken almost more than September to January.
You'll also kindly see the last order.
That's right.
No, that's right. I wanted that you should resolve the dispute. But this is so impractical. See, have you gone through that judgment of Justice Balakrishna? He says that at every stage you have to pay interest.
Yes.
I'm not disputing on that. In fact, I had
10%, 15%, 25%.
And what are you challenging? You are challenging the shaman here.
No, this is very unfortunate, Mr. Ratha, because I had given this proposal and you said...
I don't agree with that proposal.
He doesn't take.
My client doesn't agree.
Then it's fine. Now, if he doesn't agree, then let the matter come sometime next week or anytime as per your convenience, we'll argue the matter.
Why next week? Well, why should not be good now? Because 138, 9 crores of liability. You have admitted the liability. Why should it be adjourned?
Ratha, did I not speak to you and you said that you will get back to me? Have you got back to me as yet?
Right now, I'm getting back.
Right now, if you get back
My liability, your liability is 9 crores.
I'm not on the point of liability of 9 crores or no, or
No, you will not be because you have taken the money, therefore you will not be.
No, what I'm trying to say, if you would have told me today morning also that no, we are not willing for a settlement, then I would have been prepared for the argument.
No, you should have presumed it. I have never said anything that we agree. You should have presumed that we are not ready.
Tuesday, get ready. If you come with some viable proposition, we may agree. But 9 crores in every quarterly you pay, then it will take 2 years, 3 years. I don't know.
If this proposal, he should have got back to me saying no.
He says no.
Today I'm saying.
Let him give me as a proposal, then I'll talk to the client and we can just settle it. The matter goes in trial and the matter will go on for years. If he's willing for that, I have no problem. But at least let him give me a proposal, because once a judicial order has been passed by the predecessor court, so at least let that be honored for some.
See, Mr. Acharya, you have to pay the money. You give the proposal. They are the people those who accept money.
My proposal will be accepted if I say that pay it at one time. Will you accept it? No.
He will say like that only.
That I'll tell the client. If the client doesn't take,
make it two installment or 3 installment and finish it up.
That will be end of the matter.
Let him come from Mr. Rath's mouth, my lord.
No, he says that.
I only say that.
Okay, then I'll let the matter be adjourned. I'll just talk to the clients and we can.
No, either you come and a proposal which he accept it, or otherwise we'll go ahead with the matter Tuesday.
I'm agreeable to that.
Tuesday, because this is 138 matter. I have stayed it. I can't. The statute, against the statute. These interim orders are against the statute.
I know.
I can't do that. So Tuesday you come with the proposal. Maximum 3 or 4 installment, not beyond that.
Yes, that also.
Let it come on Wednesday, my lord.
Wednesday, let it be like this: 4 equal installment, and pay every month.
I'll just talk to the client and.
Otherwise, argue the matter and finish it. Yes.
Let the
Wednesday.
Interim order to continue till the next day.
There is no interim order. The interim order was the application for adjournment will be filed, and within Wednesday there is no date fixed before the trial.
Yes.
There is no date fixed.
Wednesday you get ready.
Yes.
Interim order was extended on 4th of December.
No, there is no interim order.
Right. Wednesday nothing will happen. Yes.
Nothing will happen.
Yes.
Tomorrow. Sir. The matter before the trial court is on tomorrow.
Yes.
So let the interim order be there till Wednesday, my lord.
Yes, there is nothing that will continue. Yes. Wednesday you get ready. Yes.
But the order by the Annexure 6 is under challenge, man. The petitioner before my lords is the complainant before the court below, man. He filed a complaint and pursuant to which cognizance was taken, and in course of hearing, he filed an application for under section 91 for calling for certain documents from the either to be produced by the in possession of the accused or from the bank.
Yes.
And accordingly, since in view of the admitted position, the documents were called for from the bank. Bank has submitted it. Subsequently, an objection was filed by the accused persons, and that objection is before my lords.
Yes.
I am placing it. Is at page 37, answer 5, my lord.
Yes.
There they have admitted they have taken the gold ornaments of the complainant and get it mortgaged before the bank.
Yes.
So now what the London trial court instead of and there was a letter from the London trial court.
For opposite party?
Mr. Boral was appearing.
Okay, I'll just pass over. Yes. Yes.
58.
My lord, here, your lordship may kindly turn to annexure 4.
Notice.
Page 20.
Notice.
Yes.
Service. Complete. You are appearing?
My senior, current senior is out of the sun. They bring to be agitated.
For 2 weeks, interim order to continue.
My lord, interim order, your lordship directed. I
continue the same thing. Continue. Same thing. Continue. Interim arrangement made on 25/11/2024 shall continue. At the request of opposite party number 2, adjourn the matter. Yes.
60.
May I please? But it's a small matter. Also, I have prepared a written note. But only I draw your also kind attention. I will not take any more time. 5 minutes.
1 minute.
जोटा के आसिबो नाही आधारे
That document has not been used. Money has been misappropriated prior to the estimate you have.
2005 रे गोटा एस्टिमेशन मनी विड्रॉ होला 2010 रे मते डायरेक्शन देले कहले तुम एस्टिमेशन कलो केते टंका काम होई
Money sanctioned in respect of amount to the tune of 1,30,000. So for construction of building in favor of the secretary
and president
and him. And he money has been transferred to his account. He will do the.
Who is he? Prithviraj.
Petitioner is the technical assistant. Engineer. He utilized, withdrawn the money and of doing some work, he misappropriated the money. That is the argument case.
Who?
The secretary.
The secretary and the
Secretary. Okay.
And in respect of 409, 31C is made out. But this is only is not. The money has been utilized in 2007.
2007.
Misappropriated 2007. And in 2008, the secretary headmaster retired from service.
Money misutilized, huh?
Misutilized.
Utilized. Yes, 2008.
That.
Who? Main accused.
No. It was not reported. 2010, at the instance of the petitioner, he wrote the letter to the authority that without the executors, there was money at the thereafter, vigilance inquiry was taken. And this petitioner was has made an estimate. Estimate to the tune of rupees. Actual estimate of 59,642.
Yes.
59,000?
642.
642.
Okay. Vigilance technical estimates on 54,200.
No, what? This is misappropriated amount.
No. Anko estimation है ला काम वाले दिखे ही ची. 59,642.
Vigilance says that it is in fact 54.
54,202 rupees.
202 rupees.
So thereby, जब अब क्या होता है 440 प्रकार क्या?
440.
This petitioner made the estimate in 2010. Money was estimated in 2007. Now they have not estimation. It is admitted. Evidence says on scene item that was
ground level
royalty are missing. Vigilance are missing.
Yeti difference.
Conviction against out we need to document that estimate senior consultant has verified that is the executive.
As approved.
तारो ये अच्छी हार्ड कॉपी हाईलाइट करके दे दो यार कर देंगे एपी ले लो उनको हाईलाइट करके दे दिए
वो नोटটা दे दीजिए
कोई
सेट up
then you just give me the
वो दे दीजिए मुझे
give a note so that and so उतरे रही you otherwise see this is a big burden on me by writing
no वो डेट गुड़ा भी सब लिखी दीजिए सब लिखी दीजिए
I hear for 5 minutes and I spend 2 hours to write so that is
not going to unnecessarily charge.
Mr. Maharaj, I give it to give you the
I have given
and sit together and find out what are the position and yes that it is easier. No, if you quote that, it's easier for me to quote na from there.
Yes.
Judgment reserve and the written note to be filed by both the sides.
Yes.
Yes. Ultimate. That's see that's what Mr. Maharaja was also doing the same thing. That's it.
31 D average of officer person for paper exam.
Hmm.
120 B exam, 120 paid off.
କିଛି ନାହିଁ ଆଉ କଣ ରହିଲା
ସେ ସବୁଥିରେ ଆକ୍ୟୁଟାଲ କରିଦେଲେ
and 2007 money was utilized and ଖାଇ ପିଇକି ସବୁ ବରାବର ହେଇଗଲା
477 ଏର କନେକ୍ସନ ରହିବା ଦରକାର ତାହେଲେ ନା ନାହିଁ ତ କିଛି
that you clarify in your
Yes, I have given a written note. My friend.
yes yes sir
Yes.
within it
Obliged.
and Mr. Maharaj you please sit with him
Yes, 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 yes.
yes yes sir
ଯୋଉଟା ପାସ୍ ଓଭର ହେଇଥିଲା
pass over ହେଇଥିଲା sir put it to next week Monday huh? Monday. Yes yes Monday. No Monday because he is not there Monday how could really